All right, great. So we're going to get started now. We're going to pick up where we left off with the right to counsel. So there are obviously two bills that deal with right to counsel. One was the actual structure and the scope of representation that was available for this access to counsel. And then the second piece is obviously the funding and where the funding mechanisms and where the funding would ultimately go, MLSC or the right to counsel fund or the access to counsel fund. So after some negotiations and some discussions, I feel like what I'd like to do is House Bill 18, which is what we amended and kind of passed out first. We need to kind of reconsider that because there are a couple of amendments that I'd like the committee to consider that deal with a bill that we heard earlier, I guess, was it this week or late last week, Delegate Hill, that dealt with the expungement of basically your record if you had redeemed after a certain period of time. It also dealt with what? With there's no notification on that side. Mm-hmm. Yeah. The second piece is that we'd like to discuss when the access to counsel kind of attaches or when you're available to have counsel. And we're going to discuss a notification procedure for the second bill, which is the fee bill, which works with this bill. So we're going to discuss the notification procedure and basically clarifying that your access to counsel, or your right to counsel, your access to counsel attaches when you are notified that your landlord is going to proceed with a failure to pay rent or an eviction proceeding. So I think we need to have a motion to recommit.
Motion to reconsider the final vote.
Okay, sorry, good. Senator Walsh-Stryker.
I would make a motion that we reconsider the vote by which JPR passed HB 18.
That's seconded. Is everyone okay with that? Okay, great. So now it's back with us. And I'm going to pass it over to counsel to talk about the three moving parts. So everyone's familiar with what we passed out. We'll go through what Delegate Hill's bill did with respect to expungement of a record. So, and then we'll walk through the notice provision as well. But let's just take one at a time. So we'll go through Delegate Hill's. All right, go ahead.
So the copies of the amendment are still being prepared for you, but if you'd like to see what I'm discussing, if you look up on the floor system House Bill 1008, you'll be able to see it imprinted because I did not make any changes to this. The first provision of that bill specifies that a landlord may not increase a tenant's rent solely because of a judgment was entered against the tenant in a failure to pay rent action under 8-401 of this title. So that's part one. Part two of House Bill 1008 that is being amended into House Bill 18 deals with the shielding of court records. So there's two types of shielding. There's an automatic provision and then there's on motion by the tenant. So automatic is 60 days after the final resolution of a failure to pay rent proceeding, the district court shall
The House Bill
1008.
And look under what?
It's the third reader version of House Bill 1008.
House Bill 108, it says an amendment number.
It's the whole bill, House Bill.
Oh, third reading.
Yes.
Okay.
You got it. Yeah.
So what page are we on? I'm sorry, just trying to
So
understand.
I just went over, I'll just go from the bill because that's what you have before you. So on page 2 of House Bill 1008, it specifies that a landlord may not increase a tenant's rent solely because of a judgment was entered against the tenant for failure to pay rent. And then if you scroll down, beginning on line 31 of page 2, this is when the district court shall automatically seal court records relating to a failure to pay rent case. And this only happens if a judgment of possession was not entered and no appeal is pending. So this would happen if the landlord filed in district court and before the trial finished, the tenant probably paid the unpaid rent, the court filing fees, and surcharge. So there's no judgment that was entered against the tenant. No right of redemption was exercised. It's just done over. And then if you scroll down to page 3 of the bill, beginning on line 1, this is when the tenant can request shielding in the district court if a judgment for possession was actually entered against the tenant. So the tenant can only request the records to be shielded if the tenant exercised the right of redemption, meaning that they did in fact pay the unpaid rent and all the other charges that the district court ordered. And they can only do that after 12 months have passed since the final resolution of that proceeding. The reason why it's 12 months is because of the exercise of right of redemption. So in all counties except Baltimore City, the tenant can exercise the right of redemption 3 times. But on the 4th time, the landlord can come to the courthouse and say, this is the 4th time, and they can foreclose on the tenant's right of redemption. That's why the bill's not shielding those records before the 12 months is up. And then the other way the district court can shield the record is if the court determines that it's in the interest of justice. Beginning on line 12 is when the court may not seal the record, and that's if the tenant receives federal funds to subsidize rent. Are there any questions so far?
Let's go ahead. Senator West.
Federal funds to subsidize rent, does that refer to the funds that are coming to the state from the federal government pursuant to these various large bills coming out of Washington? Or is that some separate federal program we're talking about?
Section 8 subsidized housing, right?
That's what I read it as.
So I read it as the subsidized housing vouchers. Housing vouchers. Section 8. Housing vouchers.
Okay, so this doesn't refer to the $800 million of money we're talking about here.
The rental assistance money that's coming through, no.
Can we make that explicit?
Can we make that explicit? Because that would encompass a lot of people, I imagine.
I don't think that's necessary because it says federal funds to subsidize rent required under the lease agreement.
Okay.
So no one right now has a lease agreement that's requiring
It's
subsidized funding
I see, okay.
for COVID.
Right, so this is just Section 8 housing. So the reason for sealing these records in the first place is what?
So under current law, a tenant could show up to trial and win a failure to pay rent case by showing a receipt, for example, that they had in fact paid the rent and that it was a clerical error, but that record will stay on their record forever. They can't seal that. They can't expunge it, even though they won. And the other cases would be the tenant did exercise their right of redemption, but a year has passed, 4 years have passed, it'll still show up on the record.
My point is that the general rule, which is almost always the case, is that any court records are open to public inspection. So who do we expect would want to read over these records that we want to prevent from reading over these records by allowing them to be sealed?
Well, I think part of the ways that credit reporting agencies find out is by scouring court records. And so this is an attempt to prevent a potential tenant from getting a bad, a ding on their credit report.
Okay, so the only problem with that, I don't have any problem with that, but the difficulty in accomplishing what you're trying to accomplish is, my understanding is that these credit agencies take a pass through the records like weekly, and they glom up everything that's there, especially everything that's new in the past week that wasn't there a week earlier. And you can seal the records all you want, but that won't stop the fact that or obscure the fact that the credit reporting agency has all the records. You're not sealing those records because they're in the possession of the credit reporting agency. I mean, it's a case, I think, of trying to close the barn door after the horses escaped. But I'm not opposed to trying it.
No,
but
I was
think we're
thinking
going to
more
find all
along
the
the lines
horses
of
have long since departed.
Future housing opportunities is what I was
It's
thinking.
both, yeah.
Yeah, I mean, I think both and, but my mind was more focused on the, future quality housing opportunities. whereby you'd have to have a check that's conducted. And if you're able to clean yourself up, proven you've got a track record of at least a year of good stuff, then you're
So
not
the
gonna-
concern is that a future landlord, the tenant supplying it
That's exactly
to
it.
another
Right.
place,
Right.
and the landlord, instead of using a credit reporting agency, would
Right.
instead go right to the court records.
Right.
And won't be able to do that now.
Right.
Okay. I'm still not sure we're going to accomplish much with this, but I see what you're getting at.
Amending this language onto House Bill 18,
It's just those provisions which,
just those provisions that we discussed.
it's taking it from, on page,
Can we get Kathleen?
so we're looking at on page 2, line 31 through page 3, line 11. Is that what you're talking about? Or is it, I guess it goes further than that, huh? No, it's further than that.
Of House Bill 1008. No. So we're on Amendment 9, but I put them both together because they crossed over between each other.
Thank you. I'm just trying to get some clarification here. So if I pay my rent late, yet I pay my rent before I get to court, I get the fact that I paid my rent late taken off my record, or is sealed, or is shielded.
So under that hypo, you are not exercising the right of redemption. You're just paying before you had the trial, and that would be an automatic sealing, which the district court would need to do within 60 days.
So, all right, let's go to the next hypo. The next hypo is, if I'm a law enforcement officer and someone accused me of something, yet it's unfounded, that can never get expunged. And when I go get that next job, that could affect my ability to get hired somewhere else, even though I'm innocent. So we're actually looking at sealing this type of information for that sake, but not any other piece. Just looking for clarity.
Yeah. Obviously not criminal misconduct or conduct, but yes.
No, I mean, unfounded is administrative. I mean, that's administrative.
Can we just stay, before we get down this spiral, all right, we're going to talk a lot about police in a second here, but let's just stay off this. Can we stay on the subject? All right, Senator Carter.
Thanks, Mr. Chair. Just briefly, it's apples and oranges, as you said, but to be clear, people that are applying for rental properties are still oftentimes subject to background and credit checks. So this is, the way I view this is just to keep it out of the public scrutiny, public view, which is really nobody's business anyway. Not really. I mean, it's not about employment. It's just a stigma that probably goes with it. But it's probably not going to affect their ability to rent again, because whatever is the truth is going to be revealed in the background check.
Yeah. I mean, look, I realize some people would pay the money for a credit check, but for your smaller landlords, a simple check of the online docket will tell you that the person you're thinking of renting to has done this, he does this every 6 months and moves on to a new landlord. I'm just, as we move forward with all these efforts to tell landlords they can't they can't, they get penalized for going after a tenant. They get penalized, they incur additional costs. Their remedies are limited. The only proper response by the landlords is going to be extra cautious going into the tenancy, which means they need to do their due diligence beforehand, which means checking the court records. But we're taking that away so that you can't even see that this tenant's had a judgment. I mean, I don't think any landlord will hold it against a tenant if they've had one of these judgments, but the tenant could have a dozen of these judgments in a 15-month period, and they exercise the right of redemption and then move on, which any reasonable landlord would say this is a bad risk, but we're not going to allow them to do that. So if this was done in isolation, but I have to consider this bill in light of everything else we're doing to penalize landlords, it seems like we're going a bit of a step too far, because you're only penalizing landlords who would use these things to say this tenant's a bad risk. That's my first point. My second point is it says on the bill, we're on page 3 in line 24. It says the tenant may obtain a copy of an order issued under this subsection at any time from a clerk of the court on proper identification without a showing of need. So this is a sealed court record. Normally a sealed court record, a judge has to say unseal it, but we're going to a court clerk and we're giving any kind of a proper ID, whatever that means, I'm not sure. They can see it, but nobody else can. I'm not sure why a tenant needs to go see it, but they'll be able to go see this sealed record that the landlord can't see. And that's just on showing an ID and you unsealing a record. Courts generally take sealing records very seriously. The record's sealed, and the judge has to issue an order to the clerk saying, unseal it. This is saying, no, just give that discretion to a clerk, the clerk at the front desk, to unseal a record. That's unusual.
As long as we have it for consideration. But this one, the right to access, like the notification, when that has to attach at the point of notification. Are you guys opposed to that? If not, we can put it on the other bill. You can vote against that one as well. But so what we're trying to say is that your access, your right to counsel, your access to counsel attaches when you get notified. So we're going to add a notification provision in the next one. And I talked to some of the landlord folks, and they are more, we'll have that discussion in a second, but as opposed to fees passing along, they're more amenable to something like that or some hybrid than just precluding all fees being passed on. So what we want to do is provide a notice that the landlord intends to file, and it's 7 or 10 days notice. That way you get an opportunity to meet with your counsel, figure out resolve the matter before you even get to court. There's a judicial economy argument to be made there. You kind of solve the problem before you get to court. So that's the easier of the two amendments that I'm proposing to put on this one. If there's no opposition to that, then we can just close that deal now, move on to the other bill that's going to have more opposition, and we can move forward on that end. But Senator Cassidy, go ahead.
Yeah, I never heard even yesterday in the discussion. It seems to me what we're really saying is, so we have these MLS, these entities. I guess they're all nonprofit. I don't want to assume anything, but there are these entities who are providing counsel, and they're doing this on grants. So all we're really saying is that the grant, like if I'm one of those guys who's one of those lawyers who's representing tenants, I can start billing. Basically, the tenant can come to me and say, landlords told me they're going to evict me. Can you help me now? Currently under the bill, I have to say, well, go away, and when you get served, then come back. I mean, your point that let's intervene now, get the lawyer in now. And all we're really saying by this is because now we're restricting, because it's in the law, that nonprofit or the assisting lawyer really, they can do a pro bono if they want to, but they can't actually touch the case if you walk in with the summons, right? Which is sort of counterproductive, and I agree. I don't have any problem with that piece of it.
I think it's two things. I think, and I agree with what Senator Castley just said, and I think there is both efficiency in trying to keep these cases out of court. So it's important to attach the right to counsel earlier when the tenant first gets notice that from the landlord. So that's one, it seems to me, one piece. And the second piece is this 10-day notice period where there is that time that that the tenant and the attorney would have time to actually keep it out of the next step, to keep it out of court. So can we do those two amendments on here? Yeah. Okay.
I just want to understand the timeline because, so there are two parts, right? There's the notice, and then there's this cooling off period before the landlord can file. Okay. So is there any weight between the delinquency and the notice?
Yeah, so council's going to walk you through the timeline. Okay. So, yeah.
Is this in writing somewhere? Or just
Yes, it's in an amendment. Is it in here?
Yeah, it's written in here. It's
I'm having trouble finding.
so it's pretty long. So it would be, if you look at the amendment itself, page 5 of the amendment.
This is the one you just handed out.
Yeah, the paper copy. So not looking at the reprint, just page 5 of the actual amendment. And so this would begin on 8-401. Okay. So basically what this amendment says, this is how it would change the failure to pay rent timeline. So a tenant fails to pay rent. The landlord would then provide a tenant a written notice as specified under this amendment, and then that begins a 10-day clock. After the 10 days pass, then the landlord can file for summary ejectment in district court. So district court will issue a summons ordering the tenant to appear at trial to be held on the 7th day after the landlord filed complaint. So currently it's on the 5th day. This amendment would change it to the 7th day, and that's in addition to the 10-day notice. So the district court can adjourn for 1 business day or longer if agreed by both parties to enable parties to procure witnesses if needed. And then the next timeline change occurs after the court has issued a judgment of possession. So this means they went through the trial and the landlord won. So currently, the tenant gets 4 days to appeal, or they're required to leave during those 4 days. What this bill would do is it would increase those 4 days to 7 days. So the tenant would have either 7 days to appeal or 7 days to leave the property. If the tenant does not leave the property in those 7 days or has not filed for appeal, that's when the landlord can then go back to the court and petition for a writ of restitution, and then the sheriff can physically evict the tenant from the property.
So just to clarify, that general framework is already in place in the law now. What you're doing is bumping it out 3 days, right? For 2 pieces of it, you're giving 7. Well, we're adding a front end notice of 7 days.
10 days.
10 days. Sorry, 10 days. And then on the back end, it's 4 days in the current law. You're bumping out to 7. After you get your summons, right now you have 4 days.
Yeah. So the first is the brand new notice we're creating is before there's any filing, a 10-day notice.
This is, you're on page 9. The amendment now?
So it's made several times throughout here. But on page 7 of the amendment, it'd be 3 Roman I. So to appear before the district court at trial to be held on instead of the 5th day.
Maybe I'm looking at the wrong document. I'm sorry.
The 7th day.
My page 7 has no changes on it.
I'm looking at the actual amendment, not the reprint.
I'm looking at the amendment too. This is all new language here, then, you're saying? The underline is not bolded? Okay.
So underline is, that's current law, but if
Right.
it's bolded, that's my new language.
Right, so there's no new language on page 7.
7 instead of 5.
From 5th to 7th.
What? Oh, okay, I'm sorry, I missed that.
We're in the amendment is the 10-day.
Okay. So for the 10-day, it kind of connects in and of itself. So to get to the 10-day notice is on page 5 of the amendment. It alters when the landlord can file in district court. So it specifies that the landlord must complete the procedures required under subsection C of this section. So they can only file after they comply with subsection C. So if you flip then to page 9 of the bill, of the amendment, subsection C deals with the notice. So it says, before a landlord may file a complaint under this section, the landlord shall deliver to the tenant a written notice that includes, and then this goes over what the notice actually must include.
I still can't find the 10 days, though.
Let me see where exactly that is.
Page 10. Page 10?
Yeah. So page 10, Roman VII, what is that? 7? May cure within 7 days. Or 10 days.
Okay, so the 10 days is new, and then on page 7 of 17, it used to be 5 days, it's now increased to 7 days.
Correct.
So that's an extra 12 days. And then is there another place in here where a date is increased?
Yes, it's after the judgment has been entered.
That's
It
on page
increases it
12
from-
of 17, where
That
it
it-
increases from the 5th day to the 7th day?
It increases from 4 days to 7 days, the timeline to appeal.
I'm sorry, what page is that? Where is that? Page 14.
So one of the
Yeah.
first instances is page 13, number 3. So instead of within 4 days, it's within 7 days, and then that corresponding change is made throughout.
So we're adding 10 days up front. We're increasing it from 5th to 7th. That's adding 2 more days. And then we're taking it from 4 to 7 days, which is 3 more days. So we're adding 15 days to the process. Why are we increasing those other 2 days amounts from 5th to 7th and then from 4 to 7? We're giving the tenant an extra 10 days up front. Why are we going to add more days further into the process? What was the decision there? Why?
Shelley, do you want to speak to it or do you want me to speak on it?
I'm trying to figure out where the last piece is here.
It used to say the trial would be 5 days after the complaint's filed. Now it says it'll be 7 days after the complaint's filed. Why are we increasing that?
Yeah,
by
so
2?
I get what you're saying. The front end makes sense, obviously, to allow intervention.
Right.
The back end, there are kind of 2 pieces of the back end. It's just more time for the tenant, okay? More buffer time.
But it increases the whole process.
The whole process is elongated, but it depends, because each step you have an off-ramp, right? So like, if in the 10 days you find a resolution, you cure, then nothing ever goes to, you never get a judgment, you never go to court, you're done. If you actually get that, then you exercise your right of redemption, that's another off-ramp. But if you don't, then it keeps going to the next 4 to 7 day period of time. You're just giving yourself more, it's just giving the tenant more time. That's the policy reason. But there are several off-ramps on each gap of time.
But looked at it from the other point of view, since the tenant has so many rights to redeem, you're giving the tenant, if the tenant doesn't pay when the tenant should have paid, you're now giving the tenant an extra 15 days
So just the 10 days.
before the tenant has to redeem. That's a lot of time. I can go with the 10. I don't know about the other. I don't know why we have to give her the other 5.
The 3 are in the back end.
Well,
It's after the judgment, so.
yeah,
Which
but during the redemption period, it's before the tenant
that's-
loses his right to redeem, right?
No, it's after.
No? How many provisions of the judgments given in favor of the landlord, and the tenant fails to comply?
Where are you looking? on page
Yeah,
13.
before the warrant's issued, so it's,
I'm looking at a different place.
I'm sorry, I'm on page 14, 17.
So if it's the will of the committee to stick with the 10 days up front, I mean, obviously you have more time in between to redeem, it's giving you more time, but if the policy position is, look, up front, you can actually have counsel now to help you keep yourself out of the district court, then, that's a policy decision, which is A-okay with me, but it's up to you guys.
Yeah, I'm fine with the extra 10 days up front because it makes sense to allow the tenant to get in touch with counsel, and counsel then probably, if I were counsel, I'd get in touch with the landlord and said, how can we work out a repayment?
Exactly right.
Which will avoid the need to go to court at all. That makes sense to me. But increasing the later days from whatever it was by an extra 5 days, that doesn't make any sense. There's no policy reason to do that other than just to give to give the tenant more time before he has to redeem.
Well, or, I mean, if there is an appeal, I mean, you're giving, I'm looking at a different part, I think. I'm looking at the 4 days to the 7 days, so if there is an appeal, you're giving a little more time for the landlord and for the tenant and their attorney to be able to have preparation time.
But the
to do
4
that.
days to the 7 days goes before the court issues its warrant. And the tenant has the right to redeem all the way until the warrant is actually executed. So,
But this is after the judgment.
Thank you, Mr. Chairman. I'm good with the 10 up front, but the other days, no. I mean, you still have a landlord. I mean, look, our judicial system is set up to make everybody whole. And if I own a property and I'm renting to you and you're not paying, I should have a way to be made whole. And if you are we've added those 10 days up front. So I can live with that, but I can't live with the other pieces of it, so.
Yeah, I was just curious, currently, how many appeals are there on these? I can't imagine there's very many at all. One time. So, yeah, so that basically, people aren't appealing these. These are going to be, policy-wise, I concede what the chairman had said earlier in the argument for the bill is you're trying to get people to mediate, and the council would help mediate and all that. I've always been dubious that once you get into court, the efficacy of the bill, because I think these are pretty open and shut cases, and you can tell that the fact there was one appeal, last year? People are not appealing these, so you don't need the 5 afterwards.
Right, just to clarify, the 10 days up front is on page 10 of the amendment, right? That's what you're referring to, the 10 days up front? Some questions on that? Okay, and it's 10 days after delivery of the notice. And delivery, down on the bottom of that section, says sent by first-class mail and affixed to the door. So first-class mail would obviously be the slower. So is delivery upon mailing, or is delivery upon receipt, or is there a time for the mailing? How are we measuring delivery if it's by mail?
Isn't the mailbox rule would apply, I would assume? You can clarify that, though.
I don't know,
The mailbox is when you mail it, because that's when it's stamped. But also it specifies that you need to provide at least 2 different types of the following forms of notice.
yeah, but a tenant's never going to say, well, I'll let you do it by email instead, right? I mean, that would be your dumb tenant who you probably didn't rent to in the first place. So now you have,
I guess it would be
so now you have,
2 different types of notice.
so you think it's 10 days, that the 10 days starts from the day the landlord drops it in the mailbox?
The earliest of the two.
I would say that means, because this was done as an amendment in the House.
The earliest of the two.
So that could create an issue if there's a timeline conflict.
Yeah.
I'm sorry.
So you say that, got it. You have to say the earliest of the two, but what was your initial question about?
It says it's 10 days after delivery, and I'm not clear if delivery is upon mailing. I know the old mailbox rule, that's deliveries when you drop it in the post office, but I'm not sure we've been amending that one, I think, for years. I'm not sure if the mailbox rule still applies if you've got 7 days. I mean, if that's what we're doing, it should say this. It should say it in here.
What about to cure within 10 days after the written notice is provided? So then, if you skip down then to 2, sent by first class mail, when it's sent, that's when it's provided? Does that match up?
I mean, most,
The notice that they're planning to file, that the landlord plans to file. You said Senator Jackson.
Thank you. If we're talking about, that's typically called, I guess in layman's term, a tack-up. That's a notice that you haven't paid and they're getting to file. There's 3 forms. You get notified 3 ways. Certified mail, the sheriff's deputy takes it out and posts it on the property, and then the landlord on the property typically does that as well. So it's typically 3 notifications that the tenants get that they are, they are pending.
The question is, which one starts the clock?
Which one starts the clock?
Correct, that's the question.
Oh, I don't know that. I know that there's a return that's sent back from the sheriff's office that sends it back to the court. So
The amendment we have before us says after delivery of the notice. I think we should change that to tendering of the notice or sending of the notice.
What's the functional difference between tendering and delivery?
Well, in these days where there are 3, under this, there are 3 possible, you got to elect 2 of 3 possible ways of notice. 1 is the U.S. mail, 2 is posting it on the door, and 3 is if the tenant has consented, obviously in the lease, then you can send an email. So the email will get to him immediately. The posting in the door, in these days, I wouldn't send it by mail, especially if the delivery is required. I've gotten so much mail months lately. That's a bad way of doing it. So I don't think I'd use delivery. Now, an email, and let's change talk. An email can be delivered immediately. As soon as you send it, it's there, if you use the right email address. Posting on the door requires somebody's got to go out to the premises and spend some time posting on the door. You can prove when something is sent. You can't prove when it's delivered.
Well, you can't prove it's sent, unless.
The landlord can.
Registered.
Yeah.
So I think, again, I guess when does the clock start? I will say this, that when the sheriff's deputies post those tack-ups, there's a return within 5 days of that date. You get those tack-ups, they've got to be up by within 5 days. Then they're true tested and they go back to the courts. That's one piece. I'm not sure the landlord's notification, but the courts mail, the sheriff's post and return to the courts, and then the property manager or whomever also notifies or something. But there's, I think they have only 5 days to get those up.
And then it's the first in time, the first of the 2 which is provided. I don't know how you.
well, I think if it's, we just got to decide, is delivery mean put in the mailbox, or are we adding additional days on there? Delivery is fine as long as we just define what delivery is. If delivery is put in the mailbox, or are you saying, what do we mean by delivery? In the case of mail, obviously affixing to the door is delivered.
Yeah.
You put on the door, that was delivered. But then with the mailing, well, tenants aren't going to elect the email most of the time. It says if, the statute specifically, the bill says if elected by the tenant, the electronic delivery in one of the following forms. So you have to, the tenant has to elect, right up front, you're going to say to the tenant, would you elect, do you want me to mail this to you, effective upon mailing, or can I just email it to you? And a thinking tenant's going to say, when you mail it. You
The
can't change.
landlords draft the lease. I'll guarantee you.
Wait,
it'll
this
be
is
in
the bill. The
boilerplate
bill,
of the
the
lease.
law overtakes the words in the lease. You can't go back and interpret the law based upon what the landlord says in the lease. This says if elected by the tenant.
Yeah.
One of the following forms. So the tenant's going to have to elect whether they want it by, you're going to have to say you're going to ask the tenant right up front, do you elect to receive delinquency notices by email or do we have to mail it to you? So, I mean, if a tenant says, well, you can just email it to me, the tenant's going to, pretty quickly, the word's going to go around, well, that means that you just bought yourself less time. So a wise tenant would say, no, you mail it. It all depends on what we decide. If delivery's accomplished when you put it in the mailbox, then then that's not a problem. But if delivery is the 10 days plus 4 more days for the mailing, then you've just bought yourself 14 days instead of 10 days. I think we're being vague here, and I just want to know what the committee's thinking when you're saying delivery.
Certified mail, you can.
Nobody goes to collect certified.
This says first-class mail.
The House sponsor said that they had that discussion with the landlord, so it would be an easy way for them to prove when they put it in.
All right, here we go. Can you guys pay attention to this real quick?
So on page 10 of the amendment, how about striking delivery of? So that way it'll read, cure within 10 days after the written notice is provided. And then I'll add in, probably not in that same section, but in another little paragraph, that the 10-day notice shall begin on the first day any notice is provided. Or like the first, what was it, the first in time? The first in time.
You just punted the issue. The issue, you don't have to change, delivery is fine, you just have to say, we just specify sent by first-class mail, and we just need to put in there, is delivery effective upon the date it's mailed, or is delivery affected 3 days after that, or when the tenant acknowledges they got it, which is certified mail, not first-class mail? I just don't know what we mean, because you've just punted on that with your whole amendment there. I don't know what sent by, maybe sent means delivered. If that's the case, I think you just specify that with delivery.
Sent is sending, I thought, is how I read it.
Well, I don't know. In different contracts, you can say, when I send it, your 7 days, your 10 days starts running. I don't know whether it starts running when I mail it, or when, do I have to add in some time for mailing, or do I have to, can the tenant come in and say, well, I didn't get it until the 10th day?
When it's received, you'd only know, but if you calculate it, I think it makes sense to do when the landlord puts it in the mailbox, because the landlord's keeping track of when they can go to district court and file. If they're trying to calculate when the tenant receives the mail, the landlord doesn't know when they're going to get their mail. So if it's from the day it's postmarked, that allows the landlord to keep track of the 10-day clock, which they're the one who really cares about that, because they're the ones starting the process in the district court when they file.
Right, so then in Roman numeral I, it should be sent by first delivery, comma, delivery effective upon date of mailing.
The problem is then that 10 days really is 7 days or 5 days or however long it takes the mail to get to you. Like how, I'm not on notice.
Well, and that's why you also affix it to the door, I guess. But I'm just trying to clarify, whatever the will of the committee is. I'm just saying, and if that's the case and it's mailing, then I don't know any letter that gets there before 3 days, but now we're really saying 13 or 14 or 15 days instead of 10 days. I'm just trying to be honest up front here and say what we actually mean.
Walter and then Huff.
So I'm recognizing the same problem you're recognizing, but I'm confused as to why counsel's solution does not cure the issue. So in my mind, the problem is that on C1, it uses the phrase shall deliver, but then later in the same section, it says the written notice required, blah, blah, blah. For mail, it says sent by. And so you've got this conflict between the word deliver and the word sent. And so by changing the word provide, by changing the word deliver to the word provide, and then defining that providing through Roman 1, 2, and 3 on the following page, and keeping the word sent for first-class mail, and then further clarifying that it's the first action which triggers the 10-day clock. That seems, in my mind, to cure the problem that both you and I recognize inherent in the conflict between the two words. I remain confused as to why that is not the appropriate solution.
That's when it begins.
Right. You've got to do both. If there's a conflict as to when the first one happens, the first one is the triggering event.
Senator Huffman, Senator.
So I'm confused too, because we've got another bill that came over that we have now possession, House Bill 52, which that's not what we're working off, right? So House Bill 52 says a statement that the landlord may initiate an action for repossession in the district court if the tenant does not, they got rid of respond cure within, they struck out 10 and went to 7. So it looks like in the House, they went from 10 to 7, they agreed on, after delivery of the written notice, and that the tenant has the legal right to dispute the charges. So it looks like there's another bill that we have here with a different timeline and different language. So, and I'm just curious because I don't remember if any of our bills had this 10-day, 7-day language, but it seems like they struck a deal over there and went from 10 to 7. So I'm just trying to figure out what we're doing here. And why, if we're not going to do it, why don't we just use the language from House Bill 52 that they passed over here and they worked out? If you look at House Bill 52, page 9, lines 1 through 4, it says, a statement that the landlord may initiate an action for repossession in the district court if the tenant does not, they use the word cure, they struck out respond and use cure, within 7 days after delivery of the written notice that the tenant has a legal right to respond or legal right to dispute the charges.
Yeah, they're just using 7 days instead of 10 days, but it's the same issue as when does that clock start? Does it start? Yeah. I mean, well, one of my suggestions was going to be, how is it that whatever form the landlord uses to inform the tenant about their rent, right, would be a regular, already established mechanism, that be one of them, and that if it was delivered in that same, whether it's the tenant portal, in addition to one of these, that kind of would trigger.
I see what you're saying. It's just, I'm recently from apartments. For a lot of them, it's just, you just drop a check off. Like, I have lived in apartments that have a portal that you can pay with a credit card or like through a bank transfer. Mm-hmm. But then I've also lived in an apartments where I have to take a physical check down to the landlord, and I'm not being notified that my rent's due. I just know it's due on the 1st.
You're not being notified on a regular basis?
No, month? I know that my rent is X amount of money, and then I have to drop off the check in a box the 1st of the month.
Okay. I guess I was assuming that every month the landlord sends a notice or a ping or something. Okay.
I tried to do some drafting to solve this problem. So up in 8 or 7 rather, I liked Heather's proposed language about the written notice is provided. But then down in 2, down below, I would say the written notice required under paragraph 1 of this subsection. I'm sorry, I'm at page 10 of 17 in the amendment. Right. I thought that's what we were all talking about. Yeah. Just which part now? I'm down on 2 at the bottom. 2 at the bottom, okay. Right. So I say the written notice required under paragraph 1 of this subsection shall occur when either, and go down to 1, sent by first-class mail with a certificate of mailing, 2, affixed to the door of the premises, or 3, if elected by the tenant, electronic delivery in the form of one of the following, etc. So I get rid of having to do it twice, but it occurs when either 1 or 2 or 3 occurs. And the key in the first-class mail is sent by first-class mail with a certificate of mailing, so that the landlord has possession of proof that he sent the first-class mail out. Yeah.
Can Senator West read it again? I did not.
Oh, you want me to photocopy and give it to you? Oh, okay. So 2, the written notice required under paragraph 1 of this subsection shall add the words occur when either 1, sent by first-class mail with a certificate of mailing, and then the rest of it says in the bill, affixed to the door premises, or 3, if elected by the tenant, electronic delivery in the form of the following. So you have to do one of the 3. You have to fix it to the door, you have to send it by first-class mail with a certificate of mailing, or you have to send it by email if the tenant has consented to receive the email.
Thank you, Mr. Chairman. I guess I'm just trying to, I mean, we're jumping between, I think we're on like our 3rd bill now. So is this a COVID-generated landlord and tenant fix session, or are we looking to rewrite in some fashion the landlord and tenant laws? Because there's a 3, I mean, I said not too long ago that there are 3 ways that a tenant is notified that they are late on their rent. I mean, that's, whether that's the best way or not, but we're just saying it 3 different ways. So just trying to get a handle on it, because if we're doing this, if this is a COVID thing where we're helping out tenants to make sure they don't fall so far behind, will there be a sunset date, or are we rewriting the landlord and tenant laws?
So this specific, this specifically relates to when the access to counsel or right to counsel attaches. And so the notice that you're talking about, I suppose, is just something that obviously the sheriff's office does. I'm not sure if it's not in statute anywhere, or that could be once you've been for court. Yeah, but this is something different. So we're creating a new process here, or we're kind of changing the process a little bit, because we're also creating a new right to counsel, or access to counsel. So we're not, Well,
that's understandable. I mean, but even though there is a component where the sheriff's office physically attaches that late notice, and then the sheriff's office physically supervises the eviction, but it's commonly known that there were three separate ways of doing it. So, all right, I'll see if things become clear to me as we continue to.
Right, I have a question. Are we cutting down the number of means of notifying the tenant from current practice 2 to 1? So under current practice,
So currently there is no practice for providing this notice, because it's creating a new prior to filing in district court notice.
this is a new, not
Yeah,
at the
it's-
point of
we don't
restitution.
have a
Right.
notice provision here
Yeah,
in
yeah,
Maryland.
yeah. No, I
It's not like
understand.
DC.
Right. Okay, just wanted to, go ahead.
I know it's different for the people who are watching, but it's like we're creating a whole new
No, I
10
know.
days of
Up at the
runway
front.
time. That's additional. I don't think anyone could be angry about this. Okay, all right, go ahead, Senator West.
And the key to any notice is that the tenant receives it. And I think under the language I suggested, we're guaranteeing the tenants are going to receive it. And that's what's key. So by email, they get it immediately. Posting on the door, they get it immediately. And the letter option involves a certificate of mailing, so the landlord can prove that it was mailed.
in this amendment we're looking at, all the underlying language is from existing law, right? The lowercase, non-bolded, is from existing law, right? So there's already, according to this, there's already a requirement for the judiciary to develop a form entitled petition to seal for failure to pay rent action.
No, sorry. You're looking at so you're on page 7 of the amendment, correct?
17.
17, apologies. No, so this would be uncodified new language.
Okay.
So if you look at the reprint, if you have that, it'd be on the very last page of the reprint. So it would be section 2.
So I guess the suggestion would be that if we're going to have them do a form for petition to seal, they might as well do a form petition that we post on the notice, a standard notice for posting, because there's a lot of information in here, and to expect that landlords to get information about who the self-help centers are, who the alternate dispute resolution office is, there's a lot of information that if a landlord fails to, you get into court and they say, oh wait, you have the wrong phone number for the alternative distribution resolution office, so we're going to throw your case out. Or you have the address for the self-help center, it was 110, not 112, so your notice is invalid. This whole notice thing could become a major sticking point for landlords just trying to enforce their rights, and any typo would send them back. It would only be fair for something of this magnitude, which is going to change from time to time as people change their addresses and phone numbers for these ADR places, that it's a district court form. So that's my proposal, would just be to make that
I'm just going to look at
that
the DC code. I mean,
where you're already directing them
this
to
is
establish a form, that you also add in a form for the notice.
Can you say that one more time?
Sure. On page 17, it says A, on or before October 21, the Maryland Judiciary shall develop and publish on its website a form petition, a form entitled Petition to Seal. And in that same provision, you should also require the district court to develop a notice, whatever this one's called, the notice that you have to post on the door and mail, whatever that's called. A written notice in conformance with section C1. That way landlords just pick up, they can print the form off, it's a district court form, district court makes sure the dates are right. If the Legal Services Corporation says we're changing our address, they contact the district court, they change it on there. There's a form, landlord prints that off and puts it in with his letter and says, here's your notice.
The landlord's intent to file a claim against the tenant to recover possession of the unit at least 10 days before filing the claim. Uncodified language, district court creates the form.
Yes.
I think that would work. So what you could do is do something similar-ish to what Washington, D.C. does. The language is just very, very simple. It could be just a landlord shall provide the tenant with notice of the landlord's intent to file a claim against the tenant to recover possession of the residential unit at least 10 days before filing the claim, period. And then I would do uncodified language, similar to what you see on page 17 of the amendment, which you were just saying that the district court, or you could say MLSC, the district court in consultation with the MLSC shall develop a standardized form for providing the 10-day notice prior to filing complaint. So that way there's a standardized form that the landlord could use to provide notice.
That's fine. I mean, you can bet that the district court's going to cooperate with MLSC. Yeah. They're not going to do it on their own. They're going to, it will be a rule change. They'll sit down and they'll work out this form. It goes to the Maryland Rules Committee. They show them the form. They have to approve the form. So it's the district court, the circuit court, the public defender, the attorney general, everybody's on that committee. And every form comes before them, and they say, here's a new proposed form. They approve every form. So if you make the courts do it, then everybody's involved in that process, the way the courts work. So if they just develop, if the courts are responsible for it, and then we don't have to worry about landlords trying to figure out, because I'm just saying, these providers, they're going to change from time to time, and their phone numbers will change, and they can just have one, they just contact the courts and say, change our address on the form, change our phone number on the form, and then everybody's dealing with the same form.
That makes sense.
Okay, so it could be on or before October 1st, 2020, the Maryland Judiciary shall develop and publish on its website a form titled something like a notice of intent to file for eviction or a file for a failure to pay rent. And then the form required under subsection A of this section shall include, and then I could pull in what the bill had about the phone numbers and all that information.
Yeah.
This is the piece now that's going into the bill.
Correct, yeah.
Okay.
So now that, so the notice that they get incorporates information for like counsel.
Yeah, and then,
Standardized throughout the minute.
yeah, so it would be a one standardized form.
And then just to kind of, these changes from 5th to 7th days, I don't know of any court that's doing it within 5 days now. You're already at 7, 8, 9, 10 days.
Yeah, so the proposal before the committee, all it would be is just what the landlord shall provide a tenant with a notice of the landlord's intent to file a claim to recover possession at least 10 days before filing the claim, and then have the judiciary develop the form. We're not, the other provisions,
Okay.
the appeal, that was all taken out.
Okay, so if the landlord's doing all of this, and the tenants had these extra days, and they had counsel, the whole provision about you've been through all this, the lawyers are there, you've got your lawyer, and now you're still selling the lawyer, the landlord who's had to go through all this expense and mailing and filling all this out. It seems to me at that point, this punitive petition, this punitive measure that says, and by the way, we're going to punish you if you file in court anyway.
Let's not get to that piece yet. Let's
Okay.
stick right here. We're right here at this one. Let's just move on that. That's the next bill. But is everyone okay adopting the notice, the 10-day notice provision? The district courts are going to develop the standardized form. The notice is going to include information for the tenant and their ability and their right or access to counsel. Is everyone okay with that?
Yes.
I'm sorry?
I thought we were getting rid of all that, but just doing
On the back end? Yeah, we're getting rid of all that on the back end. Yeah. What? Yeah, the 10 days is it.
No, the notice, I suggested the language about, okay, fine.
Well, quick question, what I'm trying to understand. Thank you. No, and looking at page 10 of 17, is it still at least two different types of, that we're talking about?
That Senator West developed. Go ahead.
So it's not two, it's now just one.
This is also a new process, by the way. Like, this right doesn't even exist right now. It's 18. So we amended the language we just did onto House Bill 18, which passed here unanimously a couple of hours ago. So the only thing different now with that bill is the language that we just adopted.
That only I voted against.
That only you voted.
So if you voted for the amendment and you voted for the bill before, you voted for
One would assume.
But you voted for the section.
But I vote no on the bill then.
Wait, all right, but you voted for the amendment.
Yeah, I don't see, I don't have a problem with the language of the amendment as the amendment itself, so I just vote no on the bill.
Okay.
Why didn't you vote no on the amendment with me?
All right.
Confusing me.
We got, it's an amendment. We always vote yes or no on amendments and don't tie that into your vote on the bill.
Okay, is everyone okay with the bill as amended then? So you, two no votes? Okay. Castle and Huff. So that's House Bill 18. Okay. Now we're going to go on to the actual fee provision. I'm going to give council 1 second here. We'll take a 2-minute break here. We'll come right back. No, this next, we're going to conform the Senate bill to what we just did in the House bill.
They're different bills. They're like 3 different bills.
All right, sorry, but the same bill, the cross file right now, is the motions to conform what we did in the House bill to the Senate bill, which is Senator Hedelman's bill. Senator Hedelman, are you okay with that? Okay. Everyone's good. Okay, great. Now we'll move on to the next bill. House bill.
Is that what you needed?
Senate Bill 154.
That's what we just did.
We just did that. We just conformed it to what the
And
House bill.
everybody's good.
Yes.
Okay, and then how are
Wait a
we?
second, so on the final vote, though, it should be the same.
Same. Yeah.
Okay. Well, that's why I'm asking.
We fixed your other stuff, by the way.
Well, we have to do that on mic.
Got it.
Thank you. So I just passed out to you the amendment to House Bill 31. So last voting session, JPR adopted this amendment, and then I had the oral changes that were also adopted, but so I incorporated those oral changes into this bill. So if you're looking at 7-202 on page 3 of the reprint, line 9, instead of the more than, it's may not be less than the surcharge, so that may not be less than language was made throughout the bill. So then the current change in this amendment is how, yeah,
We just told the judiciary they can charge whatever they want? If we change it to not less than, so they can charge us $500 per, we've always set a limit on them.
Let's keep going through the amendment, but that's right. Not less than. Is that a floor, not a ceiling? That's the amendment. Yes. We'll keep talking.
Okay, go ahead.
but the change that's in this amendment that was not discussed the last time is how the fee will be apportioned. So right now I'm looking at lines 21 and 23 on page 3. So the summary ejectment surcharge is increased from $8 to $68. So $45 is going to the Access to Counsel and Eviction Special Fund. And then $23 of that surcharge is going into the Maryland Legal Services Corporation Fund. And then an additional change that appears in this amendment is on the next page, page 4. It's the unnumbered lines after line 4. This is paragraph 3. So a surcharge assessed for summary ejectment shall be assessed against the landlord and may not be awarded or assigned by the district court as a fee or cost against the residential tenant for the first surcharge assessed in a year, or I think 12-month period. So those are the changes that were made in this amendment since the last time you saw it.
Yeah, I'm just troubled that the not less than, because we've just punted to the judiciary setting of fees, and I don't know we've ever done that before. I mean, I think that's a legislative function, and we've always told them, here's your cap, you can go down, but this is the most you can do. I mean, I have no problem with it. We say 45 to this and whatever, 23 to that. That's not a problem, but not that I don't trust the courts, but that's a legislative function to say what the maximum fees are. Is there a reason we went for the less than instead of not more than? I mean, why do we want to give them that grace to add on?
And for the money, in the money distribution, we need to know at least the baseline of what's coming in. Just helps. It helps with more accurate projections. But go ahead. Were you going to say something, counsel?
Or what if you just do shall be?
85.
Yeah. Instead of doing floor, ceiling, just set it at 85. if that's the intent.
I think it's okay.
You're saying it's 85 for the circuit, you're saying 85 for the district? I'm not sure what you're saying.
So I think the proposal would be to strike to do away with the may not be more than, may not be less than language and just set it at the dollar amount. So for the circuit court, it would be, the surcharge is $85 per case. For summary ejectment, the surcharge is $68. And then all other district court is $28 per case.
How much do they actually need? So like,
Senator Hutt, sorry, go ahead.
so the question is, what do they actually need? Normally, when you come in and ask for a fee, it's calculated what you actually need. So I don't want to do 85 just for the sake of, because it says 85 on this piece of paper. What do they actually need?
So
I'm trying to add up their fees here. Of the 85, what, the 45 and the 23 come out of it?
Yeah, can you send him the chart that we're looking at? So there's basically, we're trying to balance between the two funds. So the bill originally came in, it had three pots of money that this would go into. One would be the rental assistance fund, one would be the right to counsel, and then the other would be the MLSC. So obviously MLSC is facing a deficit for a number of reasons, the economy being top of mind on that. We broke out, based on the charge, number of filings that would be anticipated, where the money would go, how much it would cost. So 85 would get MLSC back to where they need to be, coupled with the abandoned property fund, which is $6 million a year. And since we're getting $800 million plus in rental assistance from the federal government, we decided to nix that and channel the rest of that money into the Access to Counsel Fund. So counsel, at our prior voting session, handed out an outline of sorts that kind of showed where the money would go, and if you adjusted the fee, how much money would go into each pot, respectively. Do you need that again?
Well, here's a question. So how much annually are they going to use? How long is this $800 million going to last for?
Senator Hettleman has probably better visibility on that. I don't know if you know the answer to that question, but I know you know the numbers better than I do.
2025. There are two pots of money. The first pot is, I think, able to be used through 23, and then the second pot through 2025.
So you've got enough money to last another 4 years almost, and yet we're still taking a fee from $8 to $68 on tenants.
No, that's for the rental assistance fund.
Yeah, that's different. It's
counsel, access counsel, and the MLSC.
$800 million? Is that what you said?
$800 million is for
rental assistance.
Which you can use for what? Just giving people money to pay their rent?
Correct, and giving landlords money. I mean, there are
Yeah,
lots of...
I understand. I understand that part.
Thank you. The question that I just would like some clarity on, when I'm looking at bill page, I'm looking at the reprint, page 5 of 8, the language on lines 1 through 3, which read, the surcharge for a summary ejectment case under section 8-401 of the real property article may not be passed on to a tenant by the court or by a landlord. That's now struck. Is the intent that language is being replaced by the language on page 4 of 8, under line 4, that says a surcharge assessed under paragraph 2I of this subsection shall be assessed against a landlord and may not be awarded or assigned by a district court as a fee or cost against the residential tenant for the first surcharge assessed in a year?
We're on a couple different components here. One is the pass-through provision, which you're talking about. One is just the actual fee. Since we're discussing the fee, can we just finish up this conversation, tie a bow on this one, and then move on to the pass-through? So, Senator Hedelman, are you okay with the 85? I mean, that's where the number comes from, Senator Huff, but are you okay with just flat 85? Or, I mean, I'm not to put you on a spot, but like, instead of the latitude, not less than, the language that, yeah. Not more than, not less than.
Yeah. Yeah.
That's the same for all the fees. You said 85, you really mean that for all the fees?
Correct. Yeah.
Right.
For the district court and for the circuit court fees. Yeah.
We're not changing the numbers, we're changing the
Not changing the number, just,
Qualifier.
yeah. Is everyone okay with that? All right, so that amendment is adopted.
Okay, so let me just clarify. So,
Yep.
do you want to adopt these amendments and then work off of them and then amend those? Or do you just want to do?
The amendment before you, what does it do? Does it strike where are you? What page are you on? Because I think what it does now is it says, look, the first charge, the tenant is exempted. Subsequent charge, the way it's drafted now, subsequent charges can be passed along to the tenant within a 12-month period of time. That's what it says. So can we get Senator Sidnor?
I'm just, all right, so whereas before, I guess neither the court nor the landlord could pass something on, under this language on page 4, it can be passed through? After the first time by anyone.
First one, the landlord eats. Subsequent ones, the tenant would have to pay. It's a compromise.
What page of the amendment are you on?
Goes to follow up with what Senator Sidnor is asking. The first part of my question is, what's the rationale for now assessing a fee to the tenant, a surcharge to the tenant? And is this discretionary for the court, or it's a mandate? And then that's the first part of the question.
So under current law, the way it would work is the landlord's filing in district court. So when they file, they're paying the filing fee and the surcharge. So then if they won their case, the court can decide to award filing fees, court costs. So that way, when the tenant tries to redeem or to pay, they owe the unpaid rent, they pay the filing fee and the surcharge. The tenant would be on the hook for that amount. The landlord would get that back. That's current law. What this bill proposes to do as amended is that a surcharge assessed, so for a summary judgment, the landlord has to pay it, and it can't be awarded as a fee or cost against the tenant only for the first time that it's charged in a 12-month period.
So it can't be, but then later when it can be, is it that it just can be? So is that going to be up for the court to make a determination based on the outcome of the case?
It would go back to current law, what the current practice is.
Which is yes or no.
So most likely, yes, if the landlord is successful, that they would get awarded court costs and filing fees.
Any chance we could make it clear? Or I guess it's automatically clear because we're saying we're carving out an exception, and then after that one time, it's whatever the current law is.
Because that's not specific to just landlord. Like that's in a lot of different types of cases, you can request filing fees and court costs. So it makes the exception here on this page, but then it also specifies in the lease provision. And then also when they're filing, excluding the first surcharge assessed against the landlord under the court's article in a 12-month period.
You good? Can I move on to Senator Jackson? Are you good? All right, Senator Jackson.
Yeah, thank you, Mr. Chairman. I'm just, so, if I file, there are court costs associated with my filing. So, in this particular case, we're not going to allow the petitioner to recover court costs if the petitioner wins the case. For the first time. Why?
Shelley?
Whose bill is this?
Why? I mean,
We're on HB 31?
This is the AG bill, right? No. Senator,
well, I mean, so I would argue, and this is the reason I put my light on, I mean, I would argue that we're in a time period now where there is a lot of money right now for rental assistance, but we're in a time where there are a lot of people who are unstably housed, and there are a lot of evictions, a couple 100,000 evictions that are pending in the courts, and the courts have been backed up, and these cases are going to be coming through. And so I would say that the tenant still has an incentive to pay on time, right? If they don't pay on time, they are stuck with a 5% late fee that it's not prorated. That's a 5% of their rent that they have to pay if they're even 2 days late. Now, granted, they have different opportunities to be able to pay and to stay. I can't do this. I mean,
So after the first time.
so. Thanks. I mean, this is the reason I think that in this time of a lot of insecurity and instability, where a lot of people are under a lot of economic distress and have precarious housing situations, that a lot of times they're not paying because they can't pay right now, right? And so they have an incentive to pay on time because they would have to pay a 5% late fee, which is not an insignificant amount of money if you're in economic distress in the beginning. And that this method of filing, like on, the 6th of the month, has been a way for landlords to be able to collect rent. Now, part of what I think we're doing in the other bill is creating a disincentive for that kind of rent collection process. But I also think that raising the fee and not allowing it to be passed on will also help tenants who are already in pretty low-income folks be able to have the kind of economic space that they need to be able to recover during this period and to be able to pay their.
So, thank you. So, what I'll say this. I certainly understand the climate we're in. That climate also affects landlords at the same time. Secondly, I think that there are a lot of folks who choose to rent who aren't in tough, who aren't low-income folks. But I guess, is there a sunset on this bill?
No.
So we're changing landlord and tenant laws. I mean, I just want to know what we're doing.
Yeah.
I'm good. I've got to vote up or down. I just want to know what we're doing. And I know a little bit about this business, and if we're using this opportunity to change landlord and tenant laws, let's just say we're changing landlord and tenant laws.
Yeah, if I could comment on that, I think that the pandemic has shined a light on a lot of the inequities that exist in the current system. So yes, I acknowledge that this is responsive to the global pandemic, but it is also responsive to making some structural changes that have been in existence for a long time that need addressing. So I appreciate the opportunity to be really clear and honest about it.
Oh, no, I appreciate that. So I'd like to offer an amendment for sunset.
Just to make you just abundantly clear on this, we've created access to counsel, right to counsel, on one bill. The sidecar to that bill is to fund that enterprise. And if you sunset the funding, then you are going to siphon off the life support for the very mechanism that we just created. So I would highly recommend you don't sunset this. When we don't even know what we're done yet. We haven't finished developing out this funding mechanism piece.
All right, I'll wait because it seems like we have a number of bills that are tied in and doing the same thing.
Yeah.
So.
Just,
Can I?
Okay. Jesus.
Does he just want to sunset this provision, the pass-through? Is your intent to sunset the whole bill, or to simply sunset the provision that says that you can't pass the surcharge through? So he's not sunsetting the bill. The 68 would still come out. All he wants to sunset is the provision that says the landlord can't pass it through, or landlord, that the landlord can't recover it. That's the only. He just wants to sunset that paragraph.
we haven't adopted anything yet. So
Gotcha.
maybe we wait till we adopt something and then we can. No, we didn't. Not the pass through. We just adopted the fee. We bumped up the fee.
And he's got a motion he wants to make in a second, so we don't keep changing.
I just don't know what you'd be sunsetting because we haven't adopted it yet.
He just wants to sunset the provision that says that the landlord can't pass it through. We're saying that's tied to the current economic difficulties, crisis, whatever you want to call it. And he's saying that would, as I understand what the senator's saying, is that we're justifying the inability to pass through based upon the tenant's current financial difficulties, and we all anticipate that that's going to not be that COVID is moving through, and it won't be a permanent disability to the tenant. So he just wants to sunset the provision that says the landlord can't pass it through to the tenant for that first time, just sunsetting that paragraph, right?
Provision first and then sunset it. I mean, do you want to do that? Is that your motion?
Second.
Until you adopt the provision, and then I will offer the amendment.
Yours would do both. You'll adopt the provision and you'll sunset it. So you can do both with your motion.
Okay.
You pressing it, or you pressing your motion, or?
Michael, you want 5 years?
No, 5 years. I mean, we'll
2 years? I don't know.
we'll be depending. I just look. My challenge is if we're going to use the premise of COVID, which is a credible premise, it shouldn't be forever that a business owner, because a landlord is a business owner, whether they're doing business the way we like it or not. This some remnants of something else. I just think that there should be a sunset on when you cannot recover fees or pass that on to the tenant or the person who lost the case. We don't do that anywhere else. I'm not withdrawing. I'm going to press it. I'm pressing it. I'm not withdrawing.
All right. It's open for discussion.
2 year.
We're missing a senator. We can roll it and make the comment with Senator Hellman and then Senator Silver.
I would just like to speak on this. I said what I had to say about the pass-through, but I also want to make it very clear that this money that's being raised is going both to the Right to Counsel Fund and to Maryland Legal Services Corporation, which provides legal services to indigent people around the state for many reasons beyond landlord-tenant. So I just want everybody to be really clear about that this is a real source of funding to each and every one of our counties and jurisdictions for civil legal services that go way beyond landlord-tenant and are really, really critical to people, especially now and going forward, and especially now that Maryland Legal Services Corporation, their normal sources of income have declined precipitously, both because, well, mostly because of the courts having been closed, because of low interest rates, and this is a way to provide them with really critical funding going forward.
Senator Sidnor, then West.
No, thank you. I'll wait until after the vote because if depending upon how the vote goes, it will determine or dictate whether or not I have a question.
Thank you, Mr. Chair. So on page 5 of 8, I don't understand what's going on. Oh, I'm sorry. This has been on for a while.
Now, Senator Jackson has made a motion to sunset any pass-through provision or prohibition for a pass-through provision that we adopt, even though we haven't adopted one yet, just 5 years. Okay. Oh, sorry, 2 years, sorry. 2 years. All right, Senator Castley.
I'm sorry, I thought his motion was both to include the language on page 4, paragraph 3, a surcharge can be assessed, but that it's sunsetted. We're just rolling the sunset provision?
No, you have to adopt it, and then you have to sunset it.
Yeah.
Sunset it 2 years, so that's the motion.
Yeah, that's what I'm saying. I think what I'm saying is what he's saying, which is we're adopting the language in the paragraph and sunsetting it. You said we're just voting on the sunset, and I thought what he said is he wants to adopt that paragraph 3 at the top of page 4 with a sunset provision of 5 years.
Yes, 2 years.
2 years, sunset provision of 2
Page
years.
4.
Yes.
Okay. And we're not, if we do that, we're not impacting the amount that would go to all the breakdown that we have in the first part of the bill of what money goes to whoever. He's not impacting that at all. The same monies would still go. It's just the pass-through provision. So, thank you.
Okay, let's roll it. Roll call.
Vice Chair Watchdrinker.
No.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Pass.
Senator Sidnor.
No thanks.
Sorry.
No.
Senator Jackson.
Yes, and I think, we just, again, I'm going to go back to where we started when we came in this room today. We've gone through maybe 3-4 bills, that we were hopping through bills, and it seems to me that we're rewriting the landlord and tenant laws, and that's fine if that's what we're doing. But for a business owner who goes to our court system to be made whole and has to come out of their pocket to pay for fees, and they're not allowed to get these fees if they win the case, to get these fees back, and to hold that in perpetuity, I think is wrong. So I vote aye.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator West.
Yes.
Chairman Smith.
No.
All right, the amendment fails.
All right, Senator Sidnor, go ahead.
Thank you. The question that I was trying to get at, because I'm reading the language that was deleted on page 5 differently from the language that's been included on page 4, whereas on page 5 it was an express prohibition that neither the court or the landlord could pass on this surcharge. I'm reading page 4 to read that the district court may not award the surcharge to a landlord, but to me it doesn't say anything about the landlord not then passing this fee on to the tenant. But I think the discussion here has been that they, for the first time in 12 months, they can't do it. That's the intent. And if that's the intent, I'm wondering if we should just be more clear about the prohibition of what the landlord can and can't do. Thank you.
I'd actually like to make an amendment to on top of page 5, lines 1 through 3, to remove the cross out.
So then you would strike the new amendment on page 4?
So strike 1 to 3, okay? 1 to 3, right?
What about the lines on page 4?
Page 4.
Then you first surcharge on these.
Right, for the first. You'd have to alter that as well.
So you're striking 1 to 3.
I think what you want to just say is you can leave that stricken out, and then to correct signatures, just say may not be assessed by the court or imposed by the landlord. Add the landlord language in page 4.
Yeah,
Do you want to,
well, I wanted to.
We're gonna hold it here. We're gonna hold this bill until after Senator Bellman speaks and after Senator West speaks, then we're gonna hold it. And then this is the critical piece of this bill, and we have to workshop this offline. You gotta talk to some advocates, you gotta talk to some people in the housing industry. Puts 3 senators together, fix this by tomorrow afternoon. So we've gotten a long way. Added 10-day notice. We established the access to counsel. We've now funded it adequately. The remaining issue is whether or not you're going to allow for the pass-through. So which is obviously the most contentious issue before us. So we're going to hold this bill, and 3 of you you're going to figure this out by tomorrow afternoon. But go ahead, Senator Hettleman, and then Senator West.
Senator West, I'm fine. We're going to hold it.
Okay.
okay, I just had a technical question. On page 5, at section 2, much of this seems to be inconsistent with what's earlier in the bill. For example, the first line back on page 3 was the state court administrator shall assess a surcharge that may not be less than $85 a case. And here, the line is state court administrator shall assess a surcharge that may not be more than $85 a case. Why aren't we striking this language?
So what you're seeing on page 5 of the amendment, section 2, this is a technical double drafting provision. So
What's
this provision would be in effect if the right to counsel or the access to counsel bill fails. So whatever JPR does to section 1, it'll look exactly the same in section 2 when you guys are done amending section 1, but the right to the access to counsel special fund will not appear here.
It's a weird.
It's a technical DLS
Okay,
double drafting provision.
I think I understand it's very confusing, but I think I understand what you're saying.
Yeah, so you guys don't need to look at section 2. It'll mirror section 1 identically, except it'll take out the access to counsel because it's just on standby in case that bill fails.
Okay, just a final comment. I really felt that we are marching towards largely a consensus here. This provision, this amendment that has just been proposed and we're going to hold in abeyance would destroy the consensus. There's no way I could possibly support a bill that would contain the language which Senator Hettleman wants to put back into the bill. And I would prefer to go to the floor and to the other house with a consensus.
This tonight and tomorrow morning, and we'll clear the deck. All right, let's take a 10-minute break, and we're gonna come back and we're gonna do the what? How many bills do we have in our possession? 6. Please, bills. Concurrence. So we got the police reform concurrence, concur, not concur, coming up. So 10-minute break. We'll come back. All right, we're gonna get started now. Everyone should have a copy of the reprints for SB 71, SB 600, and SB 178. So as you remember, and you're all well aware, we sent over nine bills relating to police reform. The House consolidated them into 4 bills. We have concurred on, we're going to go to conference on House Bill 670, which is the Speaker's bill. We have concurred with the Baltimore Police Department. And so now the question before us tonight is whether we're going to concur with Senate Bill 71, which has body-worn cameras, use of force, Senate Bill 600, which has independent investigations and demilitarization, and then Senate Bill 178, which is the MPIA, Anton's Law. So council is going to go, we'll start with Senate Bill, let's do 178, 600, and then wrap up with 71. So Senate Bill 178, MPIA. Sure.
Files on 178. Which one do you want us to open?
The Word document has the reprint, and
none of them are Word documents. 178 is 2 PDFs. One is 5627-1801, and one is 423-52001.
No, so look a little closer. I've got a Word document for 178.
the very first one.
The very first one, top left.
It's B 71? 178. God damn it. Oh, there it is. Okay.
And obviously, for just an additional point of clarification, it's a straight up, down, concur, not concur, no amendments, but questions, comments will be entertained. But go ahead. So, are you ready to go, Senator Gasly? Okay, got it.
As we're getting going, the one thing I will note is that the reprints reflect only one of the amendments. That's the amendments as the bill was reported out by the House Judiciary Committee. Actually, in each of these 3 bills, there were subsequent amendments added. Those are included in the PDFs that went out with that email. Unfortunately, just given the nature of the system, we're only able to show a reprint that shows the language with that original amendment as it was reported out. Those subsequent amendments are amendments to amendments, so it doesn't translate in the reprint. But I will fill in for the committee just on how it will read. So with Senate Bill 178, this bill, as it came in, was just for the MPIA, the disclosure of records. The House amendments retain that, but also include the work on search warrants. So the House amendments go with depart a little bit from what the Senate did on no-knock warrants. So with no-knock warrants, the application needs to be approved by the state's attorney and a supervisor. The bill takes it through what needs to go into the application. So that's found on page 2. Actually, it's not on a page number, but it's after page 2 of 4. 2 pages after page 2 of 4. And then it also limits the number of days that law enforcement has to execute a search warrant after it's issued. That goes from a current 15-day period to 10 days. It provides for requirements to be followed during the execution of a warrant. That includes officers being outfitted in a way that they're clearly recognizable and identifiable, wearing body cameras in jurisdictions that require the use of body cameras, and in the execution of warrants that are not no-knock warrants, so regular warrant execution, allowing a minimum of 20 seconds for occupants in the residence to respond and open a door before a police officer attempts to enter. And also, under certain circumstances, prohibiting officers from using flashbang, stun, distraction, or other similar military-style devices when executing a warrant, unless there are exigent circumstances. Into the MPIA portion of the bill, this begins after page 404 in the reprint. So if you go really 2 pages after page 404, this is the page that has the numbers 3 and 4, and then subsection B at the top of the page. Very much similar to what the Senate did, provides that custodian of records may deny inspection of records other than a record of a technical infraction relating to an administrative or criminal investigation of misconduct by a police officer, including an internal affairs investigatory record, hearing record, and records relating to a disciplinary decision. Distinct from the Senate bill, there are provisions that require disclosures to prosecutors. That's in the new italicized language further down on that page in subsection C. Those prosecutors are the U.S. Attorney, the Attorney General, State Prosecutor, or State's Attorney for jurisdiction relevant to the record. It also provides that custodian must deny inspection if the record relates to an active investigation or to the extent that the record reflects medical information, personal contact information of the person in interest, information relating to the family of the person in interest, or witness information. I do want to draw your attention to that. That was one of the things that the subsequent amendments by the House affected, and provided that those items in D2, provides that the new language that they say is except as provided in subsection C, a custodian shall redact portions of the record described in subsection A4 of the section to the extent that the record reflects medical information, personal contact information, etc. So that really rounds us out with the highlights of the bill.
Questions, discussion. Senator West.
Perhaps counsel could let us know whether or not no-knocks can be approved from now on, assuming the bill passes, to seize property in the premises before the property is destroyed by the occupant of the premises.
Under the bill, currently it's destruction of property and danger to life or safety, I'm paraphrasing, of an individual. This limits it to that danger to life or safety. So the destruction of evidence is not a factor.
So if there's evidence of a murder on the premises, no-knock is not permitted, and the occupant of the premises would have an opportunity to destroy the evidence before the police came in.
It's just, I guess, just as far as the justification for the no-knock, the destruction of evidence is not something that would justify the issuance.
Okay. And one other question while I have the floor. The term exigent circumstances, is that defined either in the statute or the bill as adopted by the House, or is it defined in the case law sufficiently that police can be informed as to what exigent circumstances consist of?
So in the bill, it is defined to retain its judicially determined meaning. If you give me a minute, Senator, I can actually pull up some relevant case law on that and give you a little bit more detail.
Okay. Yeah, because it's a critical term, and so we should know what we're talking about.
So Senator, there's a case, Dunnock versus State, that just a couple of observations from the Court of Appeals in that case. It provided that exigent circumstances, the exigent circumstances exception to the warrant requirement is a narrow one, so this is as it pertained to the exception to the warrant requirement. Exigency implies urgency, immediacy, and compelling need. Whenever a compelling need for official action and no time to secure a warrant coverage, exigent circumstances exist. Exigent circumstances are those in which a substantial risk of harm to the person involved or the law enforcement process would arise if the police were to delay a search until a warrant could be obtained.
So let me pursue that if I could. The bill, as I read it, says the no-knocks must be executed between 8 a.m. and 7 p.m. absent exigent circumstances. So the definition you gave, urgency, immediacy, and compelling need, would suggest something that comes to the officer's attention in an immediate way. So under this bill, as I understand it, officers would not be permitted to plan a no-knock visit to someone's home or place of abode between 7 p.m. and 8 a.m. in the morning, period, right? Can you envision any set of circumstances which would constitute exigent circumstances which would permit a no-knock warrant that had been applied for to be executed between 8 p.m. and 7 p.m. and 8 a.m. in the morning? I can't think of a circumstance which would fit the standard urgency, immediacy, and compelling need. Can you?
As you said, Senator, it would need to meet those requirements in order to get around the timing requirement there.
I think I recall testimony during our hearings that it is safest for the officers to execute a no-knock warrant when the people at home are in bed asleep, rather than during the daytime when they're near whatever weapons might be handy. So what this does is literally preclude, as far as I can figure it out, preclude any no-knocks being executed after 7 p.m. at night before 8 a.m. in the morning, even though it's more dangerous to the officers to execute them during the day, correct?
Yeah, I think it would really depend on. I guess as we're discussing it, I'm trying to sort of use my imagination a little bit to think of the circumstance. But
yeah, I'll jump in. I don't want to obviously, let's not put counsel in the position of opining on the policy. But I think you can give.
Well, he's read the case law. I thought maybe there was something in the case law which would give some reason to believe that this bill, if passed, would allow under extreme circumstances a no-knock after 7 p.m. at night, but I don't see it. And if the case law doesn't show it, my operating assumption will be that they're totally off limits in Maryland from now on.
All right, is there a motion? All right, Senator Castley, go ahead.
Yeah, I'm looking. Thank you. I'm looking on page on the no-knock warrants, and they put, we considered in section F pets, but we rejected that. It says we have to advise whether section F whether there's people, other occupants, and people with disabilities, cognitive, physical disabilities. Then they added back in pets. So, correct me if I'm wrong, but what that means is that number one says, or actually the new number one, the court's supposed to weigh the life and safety of the executing officer. So I understand when you say safety of the officer, you also have to weigh, little kids on the premises, or blind people on the premises. It might also, a life is a life. A police officer's life is, as important as the other innocent people there, but then we're also supposed to weigh the lives of pets. And, judge's supposed to say, well, it's all fair because there's a cute little dog, so I got to factor that into here to see whether, the risk to the officer is justified because there's a cute little fluffy dog there. That's what we're saying here, right?
Related to information that needed to be included in the warrant, but it also was somewhat instructive to the judge on what they needed to do with that information or could do with that information. So there were circumstances in the original Senate version that the judge could actually alter the time or circumstances of the warrant execution. What's in the language that you're reading is what needs to be in the application. I will say that the bill isn't specific in terms of necessarily what the issuing judge needs to do with that information.
Well, I'm sorry, but as I look at this, it lays out, it's got to be exigent application. You're going for a no-knock, and reasonable, on the grounds that there's reasonable suspicion to believe that without the authorization, and then it goes through number 1, and then it says number 2, an application warrant under this paragraph shall contain. So these are all the things that the judge has to weigh. I mean, the judge is just looking and saying, hey, is this worth the risk? That's what we're doing. We're saying the whole premise here is that you've got to provide the judge with information so the judge can weigh it. And I'm just trying to understand when a judge is saying, I'm trying to make sure people don't get killed. I'm trying to make sure, I mean, that's really the judge's big concern. One, did you lay out authorization for a search warrant? Did you, Fourth Amendment, standard stuff for a search warrant? And then you say, we got to give the judge other information that the judge should weigh. That's why we're not just giving this for his prurient interest that, hey, judge, do you like dogs? I mean, that's not why it's in here. This is all information that's to help that judge make that weighing process. I look through every one of them. The kind of judge can get the bigger picture here about weighing the risks and who's coming in, how they coming in, what time is it, disabled people and injured people that might be on the premises. And then we say, and also pets. So clearly we're telling the judge to factor in something about pets. It's on section F. This is on, it's an unnumbered page. It's on what has to be in a search warrant application. It's those big bolded paragraphs, A through F. Yeah, and then in number F, they've added back in pets, which we considered and rejected because we felt that you ought not be weighing. I mean, for sure, the cops know whether there's pets there. That's their, I mean, don't get bit by Rover. I mean, clearly, the cops would want to know that on their own. But we're telling you, got to give this to the judge so the judge can make a determination. And this judge is trying to say, A, do you meet Fourth Amendment requirements? Is this a valid warrant? You wouldn't interfere with constitutional rights. But then the judge is going down further, kind of the whole, we add this additional language on to say, okay, but it's not just the policing interests. We also have innocent lives there that we have to weigh. So we're trying to balance this stuff out. And then we throw in pets. So the only possible reason I can see to put pets in there is because we're supposed to value pet lives along with the police, the disabled people, the suspects, and we, I don't know, to me this sounds, the fact that we would throw pets in there just seems outrageous, that would be something the judge would say, well, gosh, I really like Fluffy, so let's not do a no-knock, place the police at higher risk. Otherwise, this language means nothing, and we shouldn't just throw language in there just for the heck of it in a bill. I mean, there's a reason you add stuff into the law, and I see no reason to add that other than to weigh the pet, Fluffy's interests. All right. And then going back to the point that was raised earlier about the property, we're striking out whether the evidence might be lost. We just take that out. That's not a factor. I mean, this is like evidence of a murder where I'll never know whether you were the serial killer because you flushed the stuff. I believe you'll destroy it, but this is a serial killer, and I'm trying to do a search warrant. I want to know whether the stuff is there. I can never factor that in. The judge will never know that there's a high risk of destroying the evidence because that's not a factor he or she can take into account. So just loss of evidence is never justifies a no-knock, even though, you would want to do that to preserve evidence. I mean, I got it where the judge may say, that evidence, the evidence you're trying to protect, it's so many grams of marijuana or something, and we're not going to justify somebody getting killed in a no-knock warrant because you want to get an extra bag of cocaine. It's just not worth the risk. But we're saying it can never be considered. Just want to make sure I understand the bill right. It sounds like I do. Thank you.
I just say, I'm looking through it. I'm not going to vote for the concurrence. For one, I don't know that this language 8 to 7, I actually think it's, quite frankly, probably useless. It might be harmful, but if you're going for a no-knock warrant, clearly that's going to be an exigent circumstance. So unless I'm missing something, I think this was just put in here so someone could say, hey, look, we limited them to 7 to 8, but clearly a no-knock warrant is an exigent circumstance. The judge will find it. So I don't think that language does anything. We had talked to the committee about 15 days, and I think Senator Jackson was the one that, and if I'm wrong, I apologize, but I laid out why they needed more time. So I thought 15 days made sense. This takes down to 10. I do remember, too, that a couple people talked about that they do use plainclothes officers, and this says they have to be wearing a uniform, which I think is a problem. I don't think they should be considering the pets. They seem to also include in disclosure minor rule violations if it involves the public. I don't know what that means. I don't know why we put that in there, but I do think what's good is they do actually seem to, in C, D, and E, to exclude more information that would be available than we did. So in that way, it makes me a little bit torn, because I actually think that is better, their amendments, than what we did, or at least from what I see is amended in, and that they're making less available. But, I mean, just those small different things, I would prefer to conference and fix it, so I'll just vote no on it.
Thank you, Mr. Chairman. So I just bring into question, when we're talking about these no-knock warrants and the time of 8 a.m. to 7 p.m., right? The whole reason that when we do a search warrant, we're doing it to try to minimize the people that get hurt or affected. So the reason you do these very early morning is when people are asleep. By 8 o'clock, normally everybody's up. I mean, I can tell you that, for a long time, you dealt with a lot of these rural jurisdictions who didn't want to have, a lot of people didn't want them to have SWAT teams. They went ahead and now they have SWAT teams. And I can tell you, we put language like this in, thank God they have SWAT teams, because they are sure going to need it when they do these things in the middle of the daytime. We are, instead of being able to slip in there, grab what you need, get the guy, and get out of there, we're going to have a gun battle, right? So it's a good thing we have SWAT teams, and I just hope that everybody understands that's what this language is leaning towards. The situation that I don't understand is when we do the affidavit, it says that now all of a sudden we're going to give a copy of that affidavit, the search warrant, and the application to the defendant or to the person on the scene, which a lot of times turns out to be the defendant. And when you are serving a search warrant, you're there to receive evidence, you're there to gain evidence. If you already had everything you needed, you wouldn't be doing the search warrant. Now all of a sudden, everything that we have given to the judge in that application, we're going to turn over to the potential defendant right there. And so he's going to have full access to all probable cause that exists, which is not something that has ever been party to or we've ever had to do before when we've done a search warrant. So that's going, not only are we changing some issues about the times and how we do search warrants, but now we're also changing the complexity when it comes to the information that we are going to be given to actual potential defendants, which is pretty scary. Wearing the uniform, there is no doubt about it. When we're talking about safety, there are people to and from that affect and work in warrants. Some of them are your undercover officers, things like that you don't ever want them in a uniform. So it's definitely going to change some of the way that we do it. But clearly, we are just going to leave that part of that out of this. I think we're just sticking with the warrants right at the moment of this part of the bill, right? So I'll just leave it at that, and then we'll talk about the other part in a minute.
The bill's open, Senator, so if you have another piece you want to speak on, floor is yours.
The 20 seconds, knocking on the door and giving 20 seconds, we worked very diligently. Everybody in this room understands the fact that we should knock on the door and announce ourselves as police officers and open the door. The 20 seconds is an absolute invitation to get other people hurt, them and the officers. I just can't understand that in good conscience we can look at that or think about that and think that that is the right thing to do. That is on a regular warrant.
Yeah, no, that's what.
We do warrants on, some, if you can't prove the fact that no knock, obviously we wouldn't wait the 20 seconds when we do use a flashbang.
I wanted to understand, is that bad? Is 20 seconds bad on a regular warrant? That's what the bill says.
Absolutely. 20 seconds is horrid. I mean, you know how long 20 seconds is, and the fact is when you knock on that door, I mean, I got to tell you something. Most of us in here have had the privilege and the opportunity to be parents. And no matter what, when you catch your child doing something wrong, right, the first thing they do is, holy smokes, they're going to run, they're going to do things. When that 20 seconds, people are going to do things that they shouldn't do, right? They're going to get themselves in additional trouble. If there happens to be a weapon and you're looking through the door and they make a move for that, well, guess what? That's accident circumstances. And guess what? That person, it's game over at that point in time, right? That 20 seconds is very dangerous to add in here. I can't believe that we just routinely think about this, and we do it by a bunch of people standing around here that have never even been in that situation or gone into a search warrant. It really is troublesome that we think about it that way, and we think about people's lives, whether it be the police officer or the person that the warrant is being executed or anybody in that house. Very troublesome that we think about it in that regard.
Thanks, Mr. Chair. I don't have a whole lot to say. I think that we've grappled with these issues for most of the session. Because there's a concept in the law that says you don't need a warrant when you have two things, probable cause and exigency, I think much of the concerns that I'm hearing are not relevant to this issue. Because where you have those two things, there's no need to get a warrant, and often it is not gotten. And so, that being said, I know that people probably want to discuss, but I'm going to go ahead and put a motion to concur out.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Hedelman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Senator Jackson.
Yes.
Chairman Smith.
Yes.
7-4.
All right, the motion passes 7-4. We'll now move on to Senate Bill 600.
Thank you, Mr. Chairman. Senate Bill 600 dealt with independent investigations by the state prosecutor. As amended by the House, the bill provides for independent investigations by the Office of the Attorney General, and also includes the provisions from the Senate package relating to acquisition of surplus equipment, specifically weaponized aircraft, drone vehicles, destructive devices, firearm silencers, and grenade launchers. The provisions relating to independent investigations require that OAG, an independent investigative unit, would be responsible for investigating cases in which there's an incident involving death caused by a police officer. From there, OAG would investigate and could also investigate additional acts of misconduct that were discovered during the course of investigation. Then 15 days after the investigation, they would notify the state's attorney of their recommendation and finding, and prosecution would go from there. And I think that just hits the high points of the bill.
I'm sorry, I'm gonna need a couple of seconds to read through this bill, but what are they, explain to me, they're striking out this language in the beginning we added, knowing and willful failure. It looks like we had a lot of definitions and presumptions, all kinds of stuff that they struck out. Page 2. From Senate Bill 71, right?
No, sorry, we're on 600.
Oh, I'm sorry. I retract that question.
Yeah, I guess a couple of questions here. Thank you. I'm looking at the what it's not clear to me. So we have on page 3, it says that so the AG investigates it, then they notify shall transmit a confidential report to the state's attorney, the county that has jurisdiction to prosecute the matter that contains the findings, says that a crime has been committed and that prosecuting matter is recommended, no crime, or recommends no prosecution. Just trying to, does that mean, so then they hand it to the state's attorney to prosecute it? I'm not clear from looking at this.
The Senate version contained provisions that were struck out relating to the authority of the state prosecutor to take over in that situation, and there was the provision for a declination letter. But with this, it provides for it really sort of stops at the point where they've made their report.
Okay, so I mean, so I'm reading it right. So they do an investigation, they make a finding, they recommend prosecution, or
right,
or no prosecution, or let's see, yeah, that no crimes committed, or does not recommend prosecution, or recommend prosecution. And in this bill, that's where the process ends.
Right.
Okay, and then we had this. So now we have this law enforcement. The state police will now have this independent or staff independent investigative unit within the Office of the Attorney General to investigate these. So when we considered this, we said that, I mean, there's like, I don't know, I think on average like 20 of these max a year where police involved deaths. So, I mean, some of those are going to be, I guess, kind of open and shut. So you have maybe a handful or so that have to be really investigated. and then the state police are going to investigate this. And the reason we went for we had the ability to oversee the investigation by these folks, but we recognize that the state police don't, in most counties, the state police don't have those homicide investigators, those forensic lab people. They don't have any of that. And so we'd be standing them up and saying, for like the 6 cases that you're going to actually look at seriously a year, you're going to try to become experts. And oh, by the way, the local police respond. They begin all the investigation. They seal off everything. And 4 or 5 hours later, the special investigative team gets there, at which point the investigation is, for all practical purposes, other than maybe following down witness leads or something like that, the investigation is really concluded. So I'm not clear here. I mean, does this say, as I'm looking at this, you know, Officer Jones comes on the scene, he reports, hey, I just shot a civilian. Then everybody just freeze. We get on the phone, we call the state police, and we sit around for 4 hours till their team gets up. They didn't know this was coming. They only do this probably 6 times a year. And now we're going to sit there and don't touch anything. The evidence is going to go cold. Witnesses will leave the scene. And then we wait for these guys to come and investigate it. It's not, I mean, that's what it seems to suggest here. We identified that as a big problem because we recognize that, as in all crime scenes, everybody responds and immediately begins an investigation, sees freeze witnesses, put the tape up, start getting the evidence before the rain washes the blood away, and every evidence is lost. So it seems like we're going back to a process that we pretty much agreed would provide for the degradation of evidence, loss of witnesses, etc. And so, is that what we're saying we're going to do here? I'm just confused because I thought I don't mind where they stop it. That's fine. I don't mind if they say, hey, you're going to investigate and stop it. It's just that this investigative unit within the Attorney General's office, staffed by state cops who are not the experts in any of the stuff they're investigating. I mean, in most of our jurisdictions, state police do traffic enforcement, and that's pretty much it. They, respond to back up the locals, but they're the ones with the crime units, the homicide investigators, and all that stuff.
So obviously the locals are going to respond first, secure the scene, start their work, and then I think the way that this is envisioned, that the state police would then come and assist and then take it over and oversee. But I will push back a little bit on the state police expertise piece because we've been through a long, windy road on all this, from state prosecutor to office attorney general. But in the testimony, the 4 bills, the 4 iterations we've kind of like gone through, state police. I mean, and correct me if I'm wrong, counsel, that in the more rural jurisdictions, this kind of task falls purely under the purview of state police because those the smaller jurisdictions just don't have the capacity to carry out those duties. So that was the testimony that I received. So it's not a foreign concept for state police. I don't think they lack the expertise. In fact, I think, frankly, the skill sets align fairly well here, but it's a policy cost.
Okay, I appreciate that, but when we look at, I remember the ACLU report investigating police homicides from 2000 for a 5-year period, and there was 200 in there, and the bigger jurisdictions had like 30 or 15 or stuff, but all the jurisdictions where the state police have this kind of authority you're talking about, they had less than 1 in the 5-year period, on average, less than 1. So, and their murder rate pretty much probably reflects that. You get, I think my county had, we get like 5 murders a year or something. It's not even, and that's just that's civilian. That's not involving police. That's everything. So, I'm not sure what, even in the counties where state police have general jurisdiction, they're not those super troopers, and most of these investigations are going to be in, by the numbers we saw, it will be number 1 will be Baltimore City, Prince George's County, I think then Baltimore County, Montgomery County. I think that's the big 4, and then after that, we're talking like 1 every 5 years. It's just not a lot there. So you're gonna be in those jurisdictions. You're gonna have like top flight homicide investigators, top flight forensic investigators, crime scene, all that stuff. These guys and gals are really good because they do this stuff all the time. And we're going to say, we're going to bring us some state police from, in some of the southern counties that have this full jurisdiction, and they're going to come in and they'll be totally outshone. I mean, all due respect to them, you get good at what you do. And if you don't do it, you don't get good at it. And the science is always advancing. just seems like this is a step back. I thought our provision on that was so much better to have tell the local jurisdiction, you got it until, we'll show up and you can't interfere with us. We can come in and look at you, but don't for 1 minute think that you don't carry the ball here. You got to do that investigation. And if you screw up the investigation, bucko, it's on you, not on the special investigative unit. They can come in and look, but if somebody says, how come the evidence wasn't properly preserved, you can't be pointing to the special investigative unit because it was your investigation from the start. So if stuff is lost, the local chief, his head's going to roll or her head's going to roll because their department botched up an investigation that involved the police shooting. And they can't pass the buck to the special investigative unit. So I just see it as a major flaw in the structure right here. Thank you.
So I think we'll stay just on that topic of what Senator Cassidy was just talking about. When a incident like that occurs, that is a pretty significant incident, the number one thing, you want to get the most information and the easiest way to do it. And that is the fact of the matter is you're going to use the local officers that have informants, have different issues like that, right? That's reality. Folks, that's what happens. The fact is, in these jurisdictions where the state police have little to no presence whatsoever, and their presence is only that of traffic. Not to say that the troopers are not extremely qualified and have the ability to do this, but reality is, when you look at the big jurisdictions, they do not do this there. They do not have information. They do not have informants. And quite frankly, if I'm the local police officer and I have worked my entire career to have informants, I have everything else, there's not a chance in this world that I'm turning those people over to somebody that I don't even know on an investigation. It is going to stonewall these investigations and what we are trying to do. Whoever came up with this idea this way just hasn't done it. It is not going to be successful. We should resist this in this part of it. What we did and coming up with a task force to look at this and then use the special prosecutor was well thought out, well discussed, and it was an issue that was defendable. This is not a defendable argument. We cannot defend the fact that we are doing the right thing for the right reason. There is, that state trooper that's going to be doing there, or we can hire civilians. So I guess what we could do is hire some retired county or city police officers that currently have that expertise, so that they could assist these officers in being able to do it and teach them in these large jurisdictions. But the question that I have, we have an elected, let's say we go to a rural area, we have an elected state's attorney, we have an elected sheriff. They are elected by the people to enforce and make sure that the laws are followed. All of a sudden, there's a death, and we're going to say, oh, excuse me, Mr. State's Attorney, excuse me, Sheriff, and all your people, we're not going to use you. We're going to let this other team come in here that up until this starts, we don't know how much expertise or how many of these they've even done. We're setting the counties, the state's attorneys, the sheriffs, and quite frankly, the state police, who, by the way, we just had to put $2 million in the budget for just so they can handle all the requests that we're having right now for guns in their gun unit, right? And we're going to draw additional people from them to create another unit. There is the potential issues that this brings to policing is definitely of significance. When you have a death, you want your best people doing the best job so that we get the best result. And that clearly is not what is happening here. I don't think that was the intent, but quite frankly, that is the reality that we are dealing with. If I could ask counsel, what is meant by the term, they shall investigate all alleged or potential incidents involving the death of a person caused by a police officer? What is that actual, what is a potential incident involving the death of a person caused by a police officer?
I think the meaning on its face, Senator, I think it would be an incident where the officer or a law enforcement officer, or rather a police officer, was potentially caused the death of another person.
Is that defined anywhere here in this legislation?
No, I don't believe it is, Senator.
Okay, so, and my question, and not to you, but to the committee would be, you stop an individual who is swerving all over the road, you think he's intoxicated, you pull him over, you use your emergency lights, he steps out of the vehicle because he's intoxicated. Before you can get up there, he wanders right out into traffic and he is smoked by a car. Would that be an incident that would qualify? Right? You stopped him. Is that an agreement?
I can certainly see why that would be interpreted that way.
Okay. How about you know, and unfortunately, police officers are called to the scenes when there's people have bad days, they're threatening to take their own life. You get there and you sit there and you talk to them, right? Well, now you're talking to that individual, and you might say the wrong thing, and they, unfortunately take their life, to either jump off the bridge or blow the top of their head off. Is that an incident because that officer said the wrong thing to that person? Obviously, that person died. Is that a situation that this would apply to? The same thing applies to a car chase or any other time that a police officer involved. Because remember, we're going to get into the use of force in the next bill. But remember what the use of force is when we talk about a police officer. The use of force starts when you have an officer in uniform in presence. Just stepping out of the car, just walking by, is a use of force. So no matter what happens in that officer's purview by that officer simply being there, could potentially, under the broad scope and range of this bill, cause anything that happens in the proximity to that officer, whether that officer had any intent whatsoever, just based on the fact that they were in uniform, to put them in the trick bag here. I just think this is a not well thought out procedure.
Well, Senator, just a point of clarification that I wanted to make, and I was going back and looking at the subsequent amendment that the House offered. I don't think that this is going to clear up the questions that you have about it, but what the House's subsequent amendment did was they actually substituted the term incidents involving the death of a person caused by a police officer for police-involved deaths of civilians. So I don't know that clears up the questions that you have, but that is, the phrase was exchanged for police-involved deaths of civilians.
Thank you very much, but that still keeps it extremely muddy water.
Thank you, Mr. Chair. I'm going to be brief. This is one of those rare occasions where I'm afraid I have to disagree with the chair, who said that he believed the local law enforcement agency had the authority to investigate until the state, the Attorney General's independent investigative unit arrives. As I read this bill, it appears to me to consign sole investigatory authority throughout the entire process to the Attorney General's unit. I'm looking at the language first on page, again, can't get the page number. Well, there's no page number at the top. It's, I guess, after page 2. It's section 3-523B. A law enforcement agency shall notify the independent investigative unit within the Office of the Attorney General of any alleged or potential incident involving the death of a person caused by a police officer as soon as the law enforcement agency becomes aware of the incident. There's no provision in this bill for the local law enforcement agency to do anything except maybe stabilize the scene. Certainly, there's no authority for them to investigate. I'm looking now on the next page, which says, the independent investigative unit shall investigate all alleged or potential incidents involving the death of a person caused by a police officer. Again, no mention of any role to be played by the local law enforcement agency. And then finally, down at the bottom of that page in E, it says, to investigate and assist with the investigation of alleged criminal offenses committed by police officers, the independent investigative unit may, 1, detail one or more police officers employed by the Department of State Police, and 2, employ other civilian personnel as needed. Once again, there's no mention of their authority to assign any responsibility whatsoever to the local police agency. So based on my reading of the bill, the plain language of the bill, the local police agency, whether it's the Baltimore County Police Department or whatever, is totally excluded from the investigation involving the death of that individual. That's really all I wanted to say.
No, I got it. Thank you for that. I would just say that I'm looking at the same page, which is the subsection C, which is the section you neglected to read, which is a law enforcement agency shall cooperate with the independent investigative unit in connection with the investigation of an incident involving the death of a person caused by a police officer. That, to me, would seem to kind of intuit that there's some level of cooperation, securing the scene, cooperating as necessary. I know it's not as prescriptive as 1, 2, 3, X, Y, Z, but it is. I think this is enough to ensure that there's a level of cooperation, that they would secure the scene and cooperate as needed.
Yeah, I'll just be brief. I don't like this because clearly this is the House. The main part of the bill is the House position. We took the position. We put it into the state prosecutor, not the Attorney General, because the state prosecutor is an apolitical position. The AG is political. And also what they give to state police is problematic because state police, I happen to know, does not have the resources to do this. And they've communicated that with this committee as well. And so I guess I'll just lastly say on it, this is why you go into conference. We spent a lot of time coming up with a position. We decided the state prosecutor should do it. We had a process, I think, that actually worked. This, I think, doesn't work. But it seems we've sort of crossed the Rubicon here about just taking the House positions on things. And I just think it was better policy. Our policy, I think, was better on it. It's not a knock on them. Quite frankly, kudos to them. It's more a criticism of the Senate that we're not defending our positions anymore or trying to conference them. We spent a lot of weeks coming up with, and this is just another point. I mean, it's the same thing as the speaker's bill that we took. It was a much different policy. I happen to think our policy and the way we did it made more sense, and I think that on this one, what we did going to the state prosecutor made more sense. The AG is political, and then going to state police, they can't do it. They don't have the resources, so I don't think this works. So I don't think that we should just adopt the House position whole cloth, because I don't think it is a superior policy. I think we have the superior policy.
Thank you, and colleagues, I'll just remind you of parts of this bill when we talked about it some weeks ago, and it had to deal with military surplus. And I wanted to tell you something that happened in my district over the last couple days. There was Easter night. There was a family in St. Mary's County. Their 13 and 15-year-old sons came up missing. And the boys were not at home. and there was a canoe that was missing and one of their life jackets. And they lived close to the mouth of the bay in the Potomac there, and they were gone all day yesterday, and they were gone until just a few minutes ago. And it's important that we think about who was out there looking for them. And let me tell you, the fire departments, and there were volunteers, and there was a lot of people that were looking for those two young men. But the one people that were looking for them was the Natural Resource Police in their helicopter. And you know where they got that helicopter? From military surplus, right? That's how that helicopter was acquired. They got it through military surplus, and we in this committee made some changes to the bill, and the House adopted that bill that allowed us to continue to get helicopters in that regard the same way that this helicopter that searched for those boys today happened. Those two boys were just found in the last hour over in Virginia. They went all the way across the Potomac River, and they're fine. So it was very well, and and a lot of people are happy, and it turned out. But the thing is, it could have turned out the other way. But that is the issue when we talk about some of these things and some of the changes that we made when we debated this bill, and we really got down in the weeds and talked about it to all of a sudden get something back that has taken and removed a bunch of the changes that we did, and then we say, well, conform or not conform. It's definitely challenging to do that, and I would definitely ask us to not conform with this bill.
Sorry. Senator, I did want to point out, if you look at the surplus provision, it's just after page 2. It tracks with the Senate language. The Senate had taken out armored, and this would pertain to weaponized.
So that's exactly what I just said.
Right.
Okay. Right. I was giving us credit for what we did.
Gotcha.
Right. I was saying that's one part that they left alone. I was giving us complete credit, but there was a lot of the parts of this bill that were not left alone. That's why I said we should not conform to it.
Gotcha.
But I totally, I read the bill.
Sorry for the confusion.
It's been seconded. We can do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
No.
Senator Hedelman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Motion to concur carries.
Motion to concur carries 7-4. All right. I'll move on to Senate Bill 71.
Thank you, Mr. Chairman. Senate Bill 71 originally related to just body-worn cameras. As amended by the House, it includes provisions on body-worn cameras, but also includes provisions on employee programs and the use of force. Just running through the bill, the House amendments strike provision that was included in the Senate bill originally, dealing with rebuttable presumption under certain circumstances where an officer fails to activate a body-worn camera. The House amendments retain the body-worn camera requirement for the county police departments and Department of State Police. That's on bill page 4 of 6 of the reprint. Moving to page 6 of 6, they include the early warning intervention system from Senate Bill 74. That's the language at 3516 near the bottom of the page. And also include the language from Senate Bill 74 on employee assistance programs. Turning to, and it's not a numbered page, but it's, if you go from page 6 of 6 of the reprint, 1, 2 pages after that, starts the use of force section. So this provides that, and there's a little bit of language that's doesn't line up from the reprint because it was subsequently amended, but it is broken down in subsection D into two parts. It's circumstances that an officer may not use force in, and then also circumstances that an officer shall cease to use force in. So for D1, a police officer may not use force against a person unless, under the totality of the circumstances, and that's where the language isn't going to line up for you on your reprint, under the totality of the circumstances, the force is necessary and proportional to prevent an imminent threat of physical injury to a person or effectuate a legitimate law enforcement objective. The police officer shall cease to use force, now this is the second part, shall cease to use force as soon as, 1, the person on whom force is used is under the police officer's control or no longer poses an imminent threat of physical injury or death to the police officer or to another person, or 2, the officer determines that force will no longer accomplish a legitimate law enforcement objective. Now, if you, there's a provision that is on the next page, and I'll just briefly break and then I'll come back to what follows on the page that we were just on. But on the next page, there's a subsection I, and that relates to subsection D, and it's the prohibition on a violation. So it provides, and this is just for that subsection D, a police officer may not intentionally violate subsection D of this section, resulting in serious physical injury or death to a person. And I'll just note, serious physical injury is a defined term under the bill. A police officer who violates paragraph 1 of this subsection is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 10 years. So that, again, loops back to the language that we just covered. So turning back, and sorry to keep switching pages on you, but turning back to the last page, subsection E deals with a number of requirements for police officers. So that deals with de-escalation, intervening, rendering basic first aid, and also documenting all use of force incidents that the officer observed or was involved in. Below that, there are requirements for police supervisors. Supervisors are required to respond to the scene of any incident during which a police officer used physical force and caused serious physical injury, and also gather and review all known video recordings of a use of force incident. Following from that are requirements on law enforcement agencies, and after that, and I'm into the next page, there's provisions for required training. Officers shall undergo training when the officer may or may not draw a firearm or point a firearm at a person and enforce options that are less likely to cause death or serious physical injury, including scenario-based training, de-escalation tactics and techniques, and reasonable alternatives to decrease physical injury. Moving on, at the bottom of the page, you may recall in the Senate bill, there was a work group that was put together to assess the feasibility and implementation of the provision requiring counties to adopt body-worn cameras. This essentially moves that requirement into an already existing task force. That's the Law Enforcement Body Camera Task Force that was established in 2020. And that is about it.
Straight, the language the key language of the bill, as far as I'm concerned, is not contained in what we have before us, but an amendment to what we have before us. So this language provides the standard, says a police officer may not use force against a person, force at all, against a person unless a police officer under similar circumstances would believe the force is necessary and proportional. And that language has been changed now to say can't use the force unless under the totality of the circumstances force is necessary and proportional. So I understand on the first standard how what would happen in court. You'd have other police officers come to court and testify that based on their training and experience, the force that was used was necessary and proportional. How would you going to prove the totality of the circumstances, and who makes that decision?
I'm sorry, Senator, so who makes the decision as to what constitutes the totality of the circumstances?
Well, under the first standard, the prosecutor would call an experienced police officer as an expert witness to testify that based on his or her experience, training, the use of force under those circumstances was necessary and proportional. That's easy. Under this new standard that's been substituted, the totality of the circumstances, how would a prosecutor try to establish the totality of the circumstances, and who would make the decision as to whether under the totality of the circumstances the force was reasonable?
It sounds like the question is, would that be proven through expert testimony on this is what a police officer under similar circumstances would do, coming from a police officer as the expert witness? Is that sort of the question?
Is that how a prosecutor would have to prove this case?
You know, I'm not sure, Senator. You know, certainly the bill doesn't speak to you know, expert requirements for needing to prove that, to actually bring in an expert witness to make that assessment and testify to that in court.
So let me put it a different way. Would it be possible for a prosecutor to indict and convict a police officer under this bill for using excessive force without ever calling a professional police officer to testify in support of the state's case?
I don't know that I'm fully qualified to answer that question. I think a prosecutor would be the best person to ask about that.
Okay. My concern being that it sounds as if this new standard, totality of the circumstances, will be within the decision-making power of the jury. Whatever jury happened to be impaneled would make that decision, and therefore a policeman in the field would have no assurance that whatever force he or she should decide to use would ultimately be found acceptable to a jury. Is that possible under this bill? Yes, under this bill, is it not possible that in a prosecution of a police officer for using excessive force, the jury would be the one to decide whether under the totality of the circumstances excessive force was used? And if that's the, number one, let me ask that. Isn't it possible that that's what would happen?
That a jury would make that determination? That's the role of a
and
jury.
That being the case, a policeman in the field facing a particular set of circumstances would have no assurance that down the road a Monday morning quarterbacking jury influenced by a prosecutor would hold that the officer acted appropriately if the officer used any degree of force at all.
I don't know that there's any way for me to answer that question other than, you know, I think that could be some. I'm not sure how that's different from other criminal laws where there's a prohibition and it's subject to later review by a fact finder, be it a judge or a jury.
Okay, thank you.
Thank you. I'm looking at, so now we're going to judge police use of force based upon a totality of the circumstances test. Maybe counsel can educate me on that. To my knowledge, totality of circumstances is a test that the Supreme Court created in evaluating search warrants and the reasonableness of searches of police officers' actions under the Fourth Amendment. Has the totality of circumstances ever been applied to police use of force?
Senator,
I mean, it seems like to me, at least to my knowledge, and I'm not an expert in police use of force or the Fourth Amendment, but it just seems like totality of circumstances is grossly misapplied in this case. We'd probably be the only jurisdiction using totality of circumstances to evaluate use of force.
Senator, I mean, use of force cases are evaluated generally under a Fourth Amendment analysis. If there's a lawsuit saying that somebody used excessive force, I mean, there's a test of reasonableness. So I believe.
I thought it was like Eighth Amendment or something.
Well, that's cruel and unusual.
Cruel and unusual. Okay.
But it's you're looking at whether the seizure was unreasonable in that case. I might be butchering that a little bit.
Yeah, like a seizure is unreasonable, but I've never heard it applied to the amount of force that a police officer can use. So all the case law on totality of circumstances involves, did the police officers, do they have probable cause to do something, to seize to enter the building to seize something? It's never been applied that I know of to.
I think the seizure of the person. What I was referencing, Senator.
I'm sorry.
The seizure of the person. We're the.
Okay, so all right, did you have probable cause to make the arrest? Okay, I understand that. Okay, but that's totally different than whether the police officer used excessive force. You would say, did you have probable cause to make the arrest? Okay, we can make an arrest using appropriate force or inappropriate force, but when we determine whether you had probable cause to make the arrest, that would be totality of circumstances. But that doesn't apply to whether you executed that appropriately, whether you used the right amount of force. I'm trying to understand how it just seems to me sort of a bastardization of the law to say we're going to apply this well-defined test of totality of circumstances for reasonableness of searches or arrests, and then saying that's going to also somehow under Maryland law apply to whether the police officer used the appropriate level of force.
Senator Sidnor, I'm only going to give him a little on-ramp here because I think he has an answer that may be responsive to your question.
Okay. Thank you very much. And I'm reading from the document that was published by the International Association of Chiefs of Police. And it says, introducing Graham v. Connor, the objectively reasonable standard establishes the necessity for the use and level of force to be based on the individual officer's evaluation of the situation considering the totality of circumstances. It goes on to say the totality of circumstances can include, but is not limited to, the immediate threat to the safety of the officer and others, whether the subject is actively resisting, the time available for the officer to make decisions in circumstances that are tense, uncertain, and rapidly evolving, the seriousness of the crimes involved, whether the subject is attempting to evade or escape, and the danger the subject possesses to the community. And it goes on.
Sure, and thank you, but see what that misses, it makes totality of circumstances a portion of, because the predicate they read in there was the officer putting himself in the reasonable, it's that officer's reasonableness, and that's what we've stricken out of here, because what we had put in there is the officer under those circumstances, a reasonable police officer, when confronted with those circumstances, would reasonably believe, based upon a totality of the circumstances, that the force was required. But we've missed the whole previous piece of that, which is that we're bringing in, it's a reasonable police officer. We're just going right to the totality of circumstances and not putting ourselves in the position of the officer. So by just saying the totality of circumstances, you skip the whole reasonable officer piece, and we're just going to judge these folks. It kind of goes back to what Senator West was saying. We're just going to judge them on a juror's interpretation of the totality of circumstances, but we've not we've eliminated the whole piece of this of a law enforcement officer, a reasonable, well-trained law enforcement officer under those circumstances, executes it. And so we're just going right to the totality. So that just means the jurors don't, the fact finder doesn't say, well, this is, we're judging this based upon a reasonable police officer. It's just the totality of circumstances, which skips that piece, which I think is a critical loss here.
No, if Senator Castley was finished, I was just going to move to concur.
I just make a statement here. In a lot of, this is a really critical provision. So before we concur, I know folks are thinking, hey, we can come back next year. We can come back 2 years later. It doesn't go into effect right away. But to me, when we enact a piece like this that jeopardizes the officer's freedom, and we enact that, it's sort of like, you say we can always come back. But like if your mom pulls you aside and says, you know what, I just want you to know, I never really trusted you, and I don't really care that much for you, and then next year she tries to walk that back, the relationship is damaged. So I think it's really important for us that we don't damage the relationship that we have with the women and men of the law enforcement community. And so I think, rather than just sort of, let's just concur so we can satisfy what the House wants to do, I think we really ought to look at this as the Senate of Maryland and say, does this make sense? And what I'm saying is, it doesn't make sense because it just goes a police officer may not, I think it says police officer now may not use force against a person unless under the totality of the circumstances, the force is necessary and proportional. And so we also added the proportional, and so the police officer has to make sure. So if the suspect has a knife or a razor, then the cop can't use a gun. He has to wait. If the suspect is just lunging out a little bit but not coming to the officer, is that proportional to go out? This whole proportionality. Do we have proportionality in our bill, counsel? Yeah. So this is a major change, because to expect police officers to say, well, I got to let the risk build up a little bit, because I'm sitting here with a service revolver, and all I can see right now is he's got a knife. He may have a pistol behind his back, but I don't see that yet. So to be proportional, I got to wait till he gets his chance. We can make this like an Old West thing. So the Old West code, where I'm not going to draw till you draw. I got to wait till you get your gun out, and then it's proportional. This is not legislating in good faith to me. This is a really bad provision that to me says police officers have to, we're going to judge them not upon what a reasonable police officer would do under these circumstances. We're going to judge them what a bunch of Monday morning quarterbacks decide would be under the totality of circumstances as they view them. And then we're going to add additional provision that we're going to Monday morning quarterback and say, well, that really wasn't proportional. You should have waited. He had a real little gun, and you had a real big gun. He just had a knife, and you had a gun. And then we say, and this applies to all force. So the police, in any force, they have to factor in this proportionality thing. And to suggest that police, in the military, when you go on the offense, it's got to be 3-to-1. That's the standard rule in the military. If I'm going after you, I want my forces to be 3-to-1 on the advantage if I'm on the offensive. And we're telling the cops, no, it's got to be 1-to-1. No, it's going to be mano a mano. We want to see you guys duke it out. It's got to be fair here. This is the Old West Code. This just does not, to me, evidence good faith in this General Assembly's protection of the men and women who risk their lives every day. And then we go further than that. It says that the person on whom the force is used, the police officer has to cease using the force when the threat no longer poses an imminent threat. So was that a threat or an imminent threat? Come on, he was 10 feet back and you used force, or 5 feet back. But we've heard testimony that, depending on who the person is, they can close 5 feet pretty fast. But was that imminent? We're going to Monday morning quarterback you and say, we don't think that was an imminent threat, so you should have stopped your using of force. You told the guy to get down, but he's still standing there with his gun, or his knife. And you keep telling him to get down, but you have to stop using your force because you felt that it was no longer imminent, even though you started using this force. So I'm not following why we would even think about changing this standard, which is in effect in all 50 states right now, pretty much the same standard, and then we're going to go ahead and adopt this Fourth Amendment standard on reasonableness of searches and seizures, and apply that to police use of force. I just can't fathom that. Thank you.
Yeah, Senator Cassidy brought up a couple good points. I'm not as worried about the imminent threat. His Roman numeral 2, effectuate a legitimate law enforcement objective, I actually kind of chuckled. I mean, that's such a big loophole. You could drive a Mack truck through that. So I think clearly they were gutting that section. But I do have concerns about what was brought up, because this necessary and proper standard, this doesn't seem to be defined in the law, or is it defined in case law? Where is this defined? Now, my understanding is not. So yeah, my understanding, Senator Cassidy and everyone else, that it's not defined in this law or case law.
In context of.
Okay,
go ahead.
My understanding is we are adopting a standard here that is not defined in case law or in this law. So I have a big problem with that we are telling our officers that they're supposed to be trained to a standard that is not defined. And I would just like to know if somebody, Jamie's been answering a lot of questions here, but if we're going to adopt the House bill, does anyone here want to advocate for either the giant loophole that the House put in here, or the necessary and proportionate, or necessary and proper, which is an ill-defined standard? I would just like to know if anybody would like to advocate for the House standard here. I mean, maybe somebody can tell me why that's better.
I don't want to say nothing.
I was going to second the motion.
All right, I'm not. Well, I guess okay. I'll just make one last point then. Lastly, again, what Senator Cassidy said is correct in that the case law, this my understanding is Graham versus Connor, it is in fact the objectively reasonable standard, not totality of circumstances. Counsel, do I have that correct?
Under Graham v. Connor, it is objectively reasonable, but let me pull up a quote for you, Senator, and I think it might clarify the question a little bit.
All right. Well, I'll just leave it on this. I'll just say I understand here we're going to take the House bill, but I would just say this is why you go to conference, because these are clear problems in this bill, and nobody here even wants to advocate for the House position, and yet we're going to adopt their position. So typically this is why you would go to conference. The House would advocate their position, we'd advocate ours, and we go to conference and discuss it. So that if there's things in here like necessary and proper that are not defined anywhere, we could fix that into conference. But again, it seems, I'd just say it's disappointing we're going to accept the House standards here, and not a single person here is even going to advocate or explain why we're doing it. We've accepted some of these in previous bills even without hearings, and now we're accepting them even without an advocate.
Senator, I'm reading from a case that. So just reading from a case, it's Blair versus, I believe this is Blair v. State. In making its decision as to whether the use of force used to effect a seizure was reasonable, so this is the use of force and whether it was reasonable under the Fourth Amendment, the fact finder must consider the totality of the circumstances, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, whether he is actively resisting arrest or attempting to evade arrest by flight, and that law enforcement officers are often forced to make split-second. This may actually be the same quote that Senator Sidnor read, but this pertains to whether the use of force. So it is an objectively reasonable standard, but in determining reasonableness, that's part of the calculus.
Yeah, I'm curious on page 4. We had. I just want to make sure we didn't change the dates. These are for the body cameras, and are those dates the same? Because we made sure our counties could comply before we put those in there. I just want to make sure they didn't change those dates, because we did We did confer with our counties to make sure that we weren't going to put a burden on them that they couldn't meet.
No, Senator, that looks like, I do recall it being 23 and 25, but just the language there is still the non-italicized bold small cap. So that would be the language that the Senate
That we put in.
Yeah.
It's the same. And the Blair versus State, was that U.S. Supreme Court or who was?
The, let me just pull that up. That was the Court of Appeals, I believe.
Oh, a Maryland case.
Yeah, let me get to that was the Court of Appeals.
Thank you, Jim.
All right, so we've had a motion, it's been seconded, we'll do a roll call.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Is this to concur?
Yes, the motion is to
Concur on the bill, the House bill, correct? Yes.
Correct.
Yes.
Thank you. Senator Castley.
No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No, I don't want to concur. And just explaining my vote, once I've done voting, we've now turned what was a bipartisan, well thought out process to passing these completely on party lines. And then just lastly, I mean, quite frankly, it wasn't even much of a debate. I just find it striking that we are adopting in whole cloth whole sections of House stuff, and no one can advocate or explain whole portions of them. So no, I won't concur.
Chairman Smith.
Yes.
Motion to concur.
Motion to concur, bill 7-4. Please, all right. All right, so that concludes the voting session for this evening. We'll see you tomorrow morning. What time is floor tomorrow?
10:30.
All right, so we're not going to come in before floor. We'll vote after floor. All right, have a good night.